Well, good morning, everyone. I'm delighted to see you all. I'm Jessica Bulman-Pozen, and together with Kate Andreas and Alati Johnson, I run the Center for Constitutional Governance here at Columbia Law School. And so we are very excited today, together with the American Constitution Society, to be hosting this conference on the Constitution and political economy. As all of you in this room certainly well know, it's an important time to be talking about these issues. I think on the one hand, the failures, shortcomings of our Constitution, our institutions like the Supreme Court are glaring. On the other hand, but related, there's so much intellectual energy coming from law students, from faculty, from lawyers and activists around rethinking the Constitution, reclaiming lost constitutional traditions, and forging a new path ahead. And political economy is coming back into the story as it has been outside of the constitutional law discourse for so long. So we're really excited to bring together the people at the forefront of that conversation for this talk today and for the panels and hopefully some spirited debate as well. Before I turn over the mic, I would just like to say a really important thank you to Caitlin Walsh, the coordinator of the Center for Constitutional Governance, who is the reason we are all here today. So for everything big and small, thank you, Caitlin, for all of your tremendous work. And now I'd just like to hand the podium over first to Zinelle October, who is the Executive Vice President of the American Constitution Society, and then to Willy Forbath, who's the Lloyd Benston Chair at the University of Texas Austin School of Law, and who together with Joey Fishkin wrote a book that has inspired this conference that I'm sure you're all familiar with, The Anti-Oligarchy Constitution. And so Professor Forbath is going to help frame our discussion today and thinking about the democracy of opportunity tradition that is being recovered as we speak. So without further ado, Zinelle, thank you, and let's begin the conversation.
Oh, sorry.
That's all right. It is, but we've got it. Well, hello, good morning, and thank you for being here, everyone, both in person and virtually. I'm Zinelle October, Executive Vice President at the American Constitution Society. On behalf of ACS, I'm very excited to be here at Columbia Law School and co-hosting this really important conversation. I want to thank Jessica and Caitlin and the Center for Constitutional Governance and the Columbia Center for Political Economy for being our co-hosts today. I'd also like to thank our friends at the Hewlett Foundation for the generous support that made this conference possible. Hope you're enjoying the breakfast. The lunch is going to be good too. A special thank you to Kate Andreas, one of our faculty advisors for the ACS student chapter here at Columbia, who's nicely represented today, thank you, and Olatunde Johnson, a longtime friend of ACS, who I understand were both key to helping put this great program together today. I also want to acknowledge and thank my colleague Doris, who's here, ACS's program associate, and Christopher Wright DeRocher, who have been putting together these conferences across the country, for all of their work to help organize the logistics of this conference from ACS's end. And of course, huge thank you to Willy Forbath and Joey Fishkin. Their book, The Anti-Oligarchy Constitution, comes at a really critical time as the progressive movement reckons with the conservative capture of the federal judiciary, and in particular, the conservative takeover of our US Supreme Court. As this court continues to use constitutionalism to justify decisions in favor of the wealthy and the powerful, we must reclaim the Constitution as a progressive document that protects the vulnerable over the powerful and envisions economic justice as a core feature of a functioning democracy. As the premier progressive legal organization with over 250 student and lawyer chapters across the nation, a few of which are represented here today, ACS's mission is to support and advocate for laws and legal systems that strengthen our democratic legitimacy, uphold the rule of law, and redress the founding failures of our Constitution and the enduring inequities in our policies and laws in pursuit of a realized equality. Centering economic justice and law and political economy as part of that mission is crucial. I'm so excited to hear from this impressive lineup of speakers we have with us today. So with one more thank you to everyone who has made this conference possible, I'm going to hand it over to Willy Forbath, the co-author of the Anti-Oligarchy Constitution as well as the Lloyd M. Benson Chair and Associate Dean of Research at the University of Texas Austin School of Law. Willy?
Thanks, Jessica. Thanks, Zinelle. Thanks to Kate, Olati, Jillian, Kathleen, and our friends at ACS. So, and to all of you, it's just, astonishing joy to see so many familiar faces and so many people I've admired for so long, and also, the younger generation that's going to carry this ball. So my job is to give a really ruthlessly distilled account of Joey and my book, our take on constitutional, or the history of constitutional political economy, and why we think it's a good idea to rekindle constitutional arguments and constitutional politics around political economy on the left. For most of US history, the question whether this was a good idea wouldn't arise because political economy simply was the stuff of constitutional law and constitutional politics. Things today we see as simply economic policy were also the most pressing constitutional issues of the day. Things like the uses and parceling out of homestead, right? The tariff, free trade versus protectionism, currency, free silver, the gold standard, the greenback, labor and employment, trusts and corporations, all sides and all the major battles about how we organize and govern economic life made constitutional arguments. They made them in courts, but above all, they made them in the polity, in election campaigns and in Congress. No one doubted that the Constitution spoke to economic life. The arguments were about what it said. And these were arguments about constitutional political economy. Conservatives never stopped making them, but liberals and progressives, by and large, did stop. They stopped because they believed in the scientific and technocratic promise of the new discipline of economics, and lost hold of the insight that all these so-called economic questions are at bottom political choices, choices about the distribution of wealth, power, and opportunity. They forgot or abandoned their own traditions of political economy. And those who refused to forget or abandon them, socialists, communists, even social democrats, were shoved out of the mainstream. At the same time, liberals and progressives also forgot or abandoned their long tradition of constitutional arguments about the ways we organize economic life. Conservatives didn't forget, like Horton the elephant. They famously held on to Lochnerism and constitutional property rights and liberty of contract. They called this the Constitution in exile. And while the mid-20th century Supreme Court had no truck with these ideas, that was no impediment for conservatives, because conservatives had no truck with much of what the mid-20th century court was handing down as constitutional law. Conservatives kept right on making constitutional arguments in the polity. Brown v. Board and the Warren and Burger Court's great civil liberties and civil rights decisions inspired generations of conservatives to assail the court and its constitutional law as counterfeits and usurpers. And these same decisions inspired liberals and progressives to become defenders of judicial supremacy. So for the first time in US history, liberals and progressives fell in love with the courts and bought the idea that the Supreme Court was the final arbiter of the Constitution. Even now, we liberals and progressives have a hard time with the idea of returning to our forebears' insistence that the political branches and the people themselves should have the last word on what our constitutional principles mean. And that's especially poignant because when it comes to political economy, the conservative tradition, anti-redistributive, anti-regulatory, pro-freedom of so-called free enterprise, private enterprise rather, is one that courts can take up. As the Roberts-Alito Court amply shows, it often just requires striking things down. But the progressive tradition is one that requires much legislative work. This tradition, the one that Joey and I call the democracy of opportunity tradition, changed dramatically over time, but as we reconstruct it, it has three basic principles. First, it holds the Constitution requires us to prevent the concentration of too much wealth and power in too few hands. Second, it requires government to build and maintain a broad dispersal of wealth and power among all people. And finally, in the only version of the tradition that remains cogent today, all the people includes, right, everyone across lines of sex, gender, race, and other lines of social division and subordination. The three principles are mutually interdependent. You can't sustain the first two without the third, as the rise and fall of Reconstruction and the New Deal order demonstrate. The court's role is often simply to stay out of way and give the political branches work, fair and ample interpretation. And that often requires, right, discursively, politically, conceptually, the idea that legislation at hand is not just economic policy, but economic policy with a constitutional purpose and constitutional principles driving it. Now the Roberts Court is famously acting like a new Lochner Court, eviscerating measures like Medicaid expansion and campaign finance regulation. Today's court, right, is also sure to embrace right-wing challenges to a wealth tax should it materialize, or new labor laws should they be enacted. But there's an important difference between the fights of a century ago about matters like this and today's looming battles. Today, when conservatives say the Constitution condemns redistributive reforms, liberals and progressives like us respond by arguing that the Constitution permits them. The Constitution, we say, is silent about the distribution of wealth and economic power. Not so a century ago. Then liberals and progressives argued the Constitution not only allows redistribution, but requires it, right? This outlook meant Congress and others have a constitutional duty to enact and implement measures, labor and antitrust laws, for example, social insurance and banking reform, to build and maintain this kind of political economy, right? Happily, the glimmers of a constitutional dimension to antitrust, for example, is on the horizon. Columbia, it seems to me, is kind of the intellectual hub of a neo-Brandeisian revival in which important figures are both in the Biden administration and beginning to talk about the constitutional dimensions of their project. One high watermark of the tradition, of course, was Reconstruction. The framers of the Reconstruction amendments were clear. Congress had a constitutional duty under the new amendments to enact laws that protected ex-slave civil and political rights. But more than that, they also had a constitutional duty to provide land and education, to break up the old slaveholding oligarchy, and provide a social and economic base to the ex-slaves standing as citizens. So the idea wasn't simply, as conservatives today imagine, a colorblind principle of racial non-discrimination. It was an upending of the whole plantation oligarchy system. The three principles I sketched, they saw as morally but also practically interdependent. Right? The Supreme Court was a significant actor in all this, but it was just one. And when the stakes were high, Americans expected their representatives and their parties to flout the court when they thought the court had gotten it wrong, especially on important matters of political economy. That was Jefferson and Madison, and later Jackson. That was Lincoln and his party. That was Teddy Roosevelt and the progressives. That was Franklin Roosevelt and the New Dealers. They used or threatened to use the legislative tools at hand: court packing, court shrinking, jurisdiction stripping, among others. There are many tools to push back today against this right-wing court. Some of the panels in today's conference will discuss them, but none of them, Joey and I think, will sit well with most Americans if they seem like nothing more than tit-for-tat politics. Progressives, we think, must also convince Americans that the court is dead wrong about the Constitution. Indeed, it has the Constitution backwards. The rights that the court denies and the laws it strikes down are often ones the Constitution demands. Making this case is the work of constitutional politics. It's not easy work, especially given the legacy of mid-20th century liberal deference to the court. This legacy leads many liberals and progressives to balk at the idea of constitutionalizing our case for redistributive and regulatory reform, but the court and its patrons have already constitutionalized this arena, and their anti-redistributive, anti-regulatory constitutional precepts will continue to get turbocharged in our public debates if liberals and progressives don't meet them head on with a rival constitutional vision. I'm wrapping up. Court curbing isn't the only kind of structural constitutional reform that this tradition has championed. Making the Constitution much more open to the changeability of democracy, right? Amending the amendment rules, narrowing the space between ordinary legislation and constitutional amendment and structural reform. All these kinds of measures, as well as addressing the anti-democratic features of the Senate, the Electoral College, and other features, right, have been defended, championed in the name of these substantive principles of political economy. So we think this tradition has it right. It got a lot of things wrong, but its basic precepts seem durable. But it's not because it has a rich history. So does Lochnerism. So does the Roberts Court's account of colorblind constitutionalism. It's not because it has this rich history alone, but because the facts of the matter, the situation we find ourselves in, support the view we can't keep our constitutional democracy. We won't avert the nation's slide into oligarchy and authoritarianism unless we enact deep, inclusive political economic reform. Thank you.
So good morning, everyone. My name is Maeve Glass, and I am delighted to welcome you all to the first panel of the conference. I want to begin by thanking our organizers, our esteemed panelists, and of course, Professors Fishkin and Forbath for their monumental work that has inspired this conference. The central question that we will be investigating this morning in our time together is this: what can we learn from studying the histories of America's Constitution and political economy? Is this a history that holds within it a lost tradition of constitutional arguments about the problems of economic inequality, one that offers us imaginative or ideological resources for progressives today? Or is this a history of cautionary tales, aspirational discourse of inclusions that papered over and made disappear material realities of economic exploitation? Or is it, as with most things, some combination of both? And how do we hold things at the same time? What, in other words, are the lessons that we should take from that vast and always constructed archive of America's constitutional past? To explore this central question, we will be moving through nearly 3 centuries of time in one. We're going to move quickly. Our panelists are going to be tacking between the words that people spoke as they forged constitutional arguments about the economy, but we will also be tracking how constitutional discourse interacted with actual practice and consequences of constitutional decision-making. By way of structure, we're going to begin chronologically. We will start with the seemingly straightforward methodological question of where in the past we should begin the story of America's Constitution and political economy. How, in other words, should we begin to define the object of study? We'll then kick off the exploration in earnest. Our first stop will be to investigate the striking prevalence of constitutional arguments about the economy in the 19th century. Our guide through this era will be Professor Christine Nissan, who is the Leo Gottlieb Professor of Law at Harvard Law School, where she teaches about the political economy of capitalism, the constitutional law of money, the international monetary system, constitutional history, and legal theory. We're then going to step into the early 20th century and drop into the Socialist Party of America, where we will hear arguments about the fundamental constitutional change needed for overcoming capitalism. Our guide here will be Professor Aziz Rana, who is the Richard and Lewis Cole Professor of Law at Cornell Law School, where he researches and writes about American constitutional law and political development, with a particular focus on how shifting notions of race, citizenship, and empire have shaped legal and political identities since the founding. Finally, we will shift gears from studying questions about constitutional argumentation to focus on questions of constitutional law, with a particular focus on separation of powers and political economy, using the Public Utilities Regulation in the 20th century as our case study. And our guide here will be Professor Lev Menand, who is an associate professor at Columbia Law School, where he researches and writes about money and banking, financial regulation, administrative law, and the history of economic thought. So as you can see, we have a stellar lineup of guides to take us through a great deal of constitutional history. We'll then open up for questions from the audience, where we will be joined by Professor Forbath, and who will be willing to field questions about his opening remarks as well. And so with that, let us begin the inquiry. Now, ordinarily at this moment, I would pass the baton, but due to the unfortunate cancellation of two of our panelists, the organizers have actually asked if I would step into the role of a quasi-panelist, which I'm delighted to do, but it means that you'll have to bear with me for just a moment longer as I swap out my moderator hat and put on the hat of a panelist, and speak for just a few minutes to tee up what I think is an underlying methodological question before I step out of the way and let the real panelists begin their work. I am myself a historian of early America, which incidentally slots me into the first chapter of a chronological sweep of time, hence me staying at the podium here. But the question that I would like to take up in my role as quasi-panelist is this: where should we begin the history of America's Constitution and political economy? And the claim that I'd like to persuade you of is that depending on when one starts the clock of constitutional time and where one draws the map of constitutional space will determine the types of arguments, the archive that one recovers. And what I'd like to try to persuade you, and I'll start my clock now because I've given myself 5 minutes, everyone else gets 10, but I'm gonna try to do this in 5 if I can get to actually I'll just keep it, 9:40 will be my stop time. In the 5 minutes that I have, I'd like to persuade you that there are alternative ways that we can think about constructing the time and space of America's Constitution and political economy that might lead us to be more skeptical of the arguments that appear when we begin with the beginning of the nation. So what do I mean by this? One place to begin the clock of constitutional time is with the founding of the nation as a political entity. That famed moment when the ink of an infected oak tree met the skin of a slaughtered farm animal and they called it a constitution. If one begins the clock of constitutional time at that moment, a particular geography comes into play. The map of the constitutional political economy is one of fragments. If you close your eyes, you can probably see it in the mind's eye. We have 13 colonies turned into states at the periphery of a distant imperial center, soon to split into two feuding political economies of North and South that will in time give way to a nation reborn on the battlefield of civil war with the new possibilities of a second founding. And from that particular map of fragments and feuding political economies that begins when we start the clock of time with where the nation told us to begin our time, the arguments that will begin to sound are those of politicians and lawyers and judges questioning and arguing about the consolidation of wealth and power. Now, there's very good reason to start our clock of constitutional time with the founding of the nation. It is, as we have seen, a source of national identity, the source of a religious constitutional religionism, and the basis for debates over major economic challenges. But in my remaining 4 minutes, I'd like to explore what might happen if we were to dispense with that as the parameter with which we begin our study of the constitutional past. What would we see if we began not with the moment in which ink meant parchment and we had the Constitution, but if we began instead with the movement of capital? What if we began our archive by working from the ground up with the material world of production and exchange? The idea of beginning with the ground and moving up to study a political economy is by no means a novel one. Nearly half a century ago, a historian of colonial Mexico named Carlos Zampara argued that if one wanted to understand the construction of a political economy, one needed to begin not with the nation and its political borders, but with what term he called the económico espacio, the space of the economy, defined by zones of production and conduits of commercial exchange that preceded the jurisdictional lines laid out by the surveyor of the empire. What would it look like then to begin with the unit of study with dirt and water? 3 things would shift. First, our unit of constitutional time would change. Our study of the Constitution and political economy would begin not in Philadelphia with lawyers and politicians, but with merchants who first came to the shores of North America with an eye of translating its land and labor into private wealth and public power. Our story would begin not in 1787, but one fall day in 1636, when the first vessel of commercial partnership hauled out from the Chesapeake Bay, carrying a cargo of grain licensed for sale in New England. Our unit of constitutional space would shift too. We would begin not with the political fragments and rival economies, but with the pathways of movement, the bonds of union that Lincoln would later invoke in 1858. The coast would appear, the coast of North America, as it did to the merchants who came to its shores, a single stretch of land that held within it the possibility of paring and reaping the rewards of the sugar islands to the southward, the plantations to come on the mainland, to the centers of commerce in the New England. For some, that early version of the coast was an exact replica of the ancient Roman highways that once connected the granaries of Sicily to the metropolis of a new republic. And the merchants who cast their eyes on it would later play a role in overthrowing a distant monarch to usher in that new republic that would be based on conduits of commercial exchange. But perhaps most intriguingly, our archive of constitutional political economy would shift as well. Our paper trail would begin to change. Instead of tracking the arguments that were displayed for public consumption, we would enter into the trading houses and merchants to see how they spoke about the Constitution and the customs and laws that allowed that first ship that sailed between New England and the Chesapeake Bay to become one of the most heavily trafficked corridors of trade in the Western world. We would see, if we followed the fragments left behind by those merchant ships, a different type of constitutionalism. This is the private law of commerce, in which the customs of partnership created an understanding of an America that would be based on the united sentiments of merchants, the shared equality of states, and rooted in the agreement not to interfere with the institution of slavery and to condone the taking of indigenous lands. That would be the paper trail that would begin to emerge if we followed that particular construction of time and space and the archive that would emerge. So as we move forward into our study of the 19th century, I leave you with this methodological question. What is at stake and where we choose to start the clock of constitutional time? What happens if we begin not with the words laid down by those who have held our gaze in telling us when the nation began, but with those who have receded into the backdrop of the archive, but whose ships were among the first to begin building the networks of trade that would give rise to these United States. And with that, I'll take us into the 19th century with President Son. It's up to you.
So I'll just stay here. Maybe we can then have a more informal talking kind of atmosphere. First, thanks to the organizers and to the attendees. It's a really exciting conference to be a part of. And thanks, obviously, to Joey and Willy for kicking this off. Am I not? I can also stand there. Can you hear me now? Not good? Good enough? Better enough? Okay. So you missed the thanks, which I can repeat. Thank you for being here, and thanks to Willy and Joey. In the early 1930s, a US senator says on the Senate floor, if there has been a larger or more dangerous stretch of executive power and influence, I have not discovered it. Was he talking about the expulsion of Native Americans from the Southeast by Jackson and Van Buren? Was he talking about executive support for the tariff and the escalation of the nullification crisis? Was he talking about Jackson's intervention into Western land markets, or for that matter, Jefferson's Louisiana Purchase, right, looking backwards? No, he's talking about the claim that the Secretary of the Treasury gets to choose the place for federal deposits. Not an issue you've thought about, right? In 1837, Justice McLean says, there's no principle on which the sensibilities of the community are so easily excited. Is he talking about elections, free speech, slavery? No, he's talking about the constitutionality of bills of credit, those practices of currency that excite the people more than anything else. We were asked to address the question, how did speakers talk in constitutional terms about the political economy, in my case in the 19th century, but the question really is, how did they not talk about it? Is I really want to underscore Joey and Willy's point that constitutional discourse was pervasive. There was a broad recognition that the economy and the political were connected. I love that Maeve took us back to think about 18th century. The colonial period is one long struggle for political economic power. So if you look at and that struggle for political economic power is cast in constitutional terms. So small c constitutional terms, the British Americans are very aware of those terms, and they use them to defend their encroachment onto imperial territory, creating literally parallel economies with parallel money supplies, with newly located treasury offices into their own legislatures, with divided taxation. They seize control over their political economic futures. And they do that surely at the commercial level, but they also do it at the public law level. These are legislative debates, and they lead to the old, sort of institutional histories of the rise of the assembly. And indeed, in my opinion, they lead to the revolution. Right? They're not revolting for abstract purposes. They're revolting because they don't want to lose control of their political economies. My 19th century examples were meant to show that even fairly dry matters, things that we would think of as highly technical, are cast in constitutional terms, often explosive constitutional terms. And those terms are used by a wide variety of actors, policymakers, government officials for sure, social movements, the largest social movement in the 19th century and arguably in American history, the agrarian movement, agrarian populism, explicitly constitutionalizes economic claims and monetary claims, gets pretty technical. Political parties are themselves born and grow because of political economic claims cast in constitutional terms. So a few examples of the issues and actors who claim or shape constitutional history. Some are obvious. So I study a lot of the border zones, basically places where the economic manifestly intersects the political. To give you a few examples of the use of constitutional terms, Daniel Webster, Calhoun, when he's a nationalist, calls state banks, which are by the 1820s absolutely entrenched in American society and pervasive, they call those banks unconstitutional because of the plethora of notes they issue. That makes impossible a uniform currency. That means that undermines many national policy matters. It makes the War of 1812 pretty hard. It means that taxing in disparate notes imposes different and varied burdens on the population. The issue animates not only nationalists, but Jacksonians, obviously extreme Jacksonians, indeed, as I said, arguing political parties. Here, the Locofocos are basically an anti-bank party. Another obvious place of political economic debate, and Lev and I can talk about the Bank of the United States. We all know Marshall's opinion, which is the occasion for the announcement of sweeping congressional authority over all matters necessary and proper, right, to implied as well as enumerated ends. But Jackson makes an incredibly assertive and powerful argument that the Bank of the United States is unconstitutional as applied. So he's also a constitutional theorist. He says it clothes private profit with a public shell. That is, it dispenses privilege unfairly across the population by immunizing that private profit-driven activity. And that, along the way, the second part of McCulloch, we've displaced in that moment the authority of state legislatures to tax private profit-driven activity. The bank, along with the debt debates, the revolutionary debt debates, also produces a political party. It's those events that split Madison from Hamilton and Madison goes with Jefferson and produces the Democratic Republican Party. Agrarian populist, just to mention a third really obvious place, huge social movement based on the claim that there's a right to a cash wage, not a credit-mediated, debt-laden wage. It constitutionalizes that claim as an effective right to liquidity. It is, as one of the populist documents put it, the imperative duty of Congress acting under the Constitution to issue full legal tender paper money when gold and silver is inadequate, to enable the people throughout the United States to transact their business on a cash basis. And the populists mix in equal protection language. Here's an example: the federal government should promote equal rights and equal chances before the law. To these obvious areas of political economic constitutionalism, I would add other areas that are less obviously, but just as importantly, integral parts of a debate over the political economy. And I think once we see those areas that we think of as maybe, we think of as con law areas that aren't so infected, and once we see them as areas of political economy, I think we can't unsee it. So a few examples. Public contract, the extent of congressional or state responsibility to citizens looks like political theory, but actors from Hamilton to Marshall, and here I would say the Federalists are really in the lead, are trying to create a world safe for transactional enterprise. That's their agenda, to use the Constitution to revise and reduce legislative latitude over economic claims, legislative ability to readjust equitably economic claims. So here, think of certainly the debt debates, both federal and state debt left after the Revolution, but think also Chisholm and state suability. Right to sue a state was to take into judicial hands the legislative responsibility for remedy. Fletcher and the rights of third-party purchasers. The agenda is to broaden an arena of private purchase, private contract, protection of creditors, again and again, like a drumbeat in these early decades. At the same time, the court is, of course, reshaping separation of powers. So throughout these early decades, we see the decline of state legislative power and the rise of federal judicial power. In these cases, the contracts clause is at work, the most common instrument used by the Supreme Court to invalidate state legislation across the 19th century is the contracts clause of all things. And what the court is doing is limiting the power of state legislatures to claim redistributive authority. A related theme here, the redefinition of the corporation occurs in constitutional terms. So the corporation is redefined from a creature of the state, a grant of public power by the sovereign for general welfare, to a vehicle with significant autonomy from state authority. It will operate as a vessel that divests sovereignty from its members, leveling states. Here I'm referring to when states become or join corporate, take on shareholding, take on ownership, leveling states down to individual status. That's what happens when a state buys in, as opposed to actors with a higher responsibility to a collective, right? Become simply a counterparty. Here, think Dartmouth College, limit state legislative power. Bank of the United States versus Planters Bank opens states to suits insofar as they become stockholders. I've lost a page here. I'm sorry, I've lost where I'm going. Okay. I was on corporations, okay. Ultimately, corporations become an instrument of state expansion and development that really drives their ascent. And here, I just want to point out the fact that corporations are being used, given their new kind of revision, their reshaping, as an instrument for state power. That is, states begin to use corporations, the business vessel, to fuel state-level economic development. That includes using corporations to shield state actors from federal objection. States can do as corporations things they cannot do as sovereigns. And that is also cast in constitutional terms. So here, for the few of you who have read Kentucky v. Briscoe, a really interesting case. That is to say, what actors are doing is revising contract, separation of powers, corporate power. All of that is also reshaping federalism. Obviously, we see the, in some ways, denigration of the states and then rising power of the states through the corporate form before the Civil War. So what happens? That's another question we were asked. Why the technocratic turn? It's a real turn, to be sure. I think it is in part a function of the technocratic changes I just sketched. As far as doctrinal changes, the cumulative effect is to move a whole swath of issues from matters of political debate and discretion to matters that are judicially policed. The public obligations of the United States, for example, public debt more generally, a matter of equitable repayment and adjustment to thinkers like Adams, as well as Madison, made into a matter that can be analogized to private contract by the Federalists. Corporations move from a matter of particularized legislative grant for public welfare to an instrumentality for entrepreneurial claims, a business opportunity that anyone and everyone can claim. Yet more directly, I believe the economy is defined as distinct from politics by its re-engineering. That is to say, I think the economy itself is engineered to be divided from political control. The leading edge of that change, in my opinion, is the determination to privatize money creation. Banks operating from commercial advantage take over that public function in the 19th century. At the same time, they claim authority over allocations of credit in new money. They will become the monopolists of that decision. They also claim expertise in those areas. So if we think about that, their claims to institutional ownership, authority, and expertise, it's quite a handful, right? Quite a dramatic redesign. The maturation of economics occurs in the same period, a discipline that conceptualizes the market as based on individuated decision-making. This is marginalism, autonomous from political or other influence. Ideally, right, in order to have real independent decision-making, you need autonomy from political decision-making, and that is the market about pre-existing preferences as opposed to socially constructed knowledge. We could add a series of institutional phenomena that reinforce those trends, like the gold standard, the establishment of the Fed. So here, I guess I would say to Willy, I think it's not so much the left forgetting as real structural change, a redesign, one that changes the context and reach of legislative policy. So here, if you think about the structural change I'm sketching, revision of public contract, the ascendance of judicial policing, not just policing per se, but the endorsement, the policing in the figure of private law, right? The endorsement of common law modes of thinking as applied to the state. The institutionalization of privatized money creation, the transformation of corporations, the limiting of legislative tradition of credit expansion and allocation, the endorsement of capital markets as a practice with its own logic, which I'm about to mention, the isolation and immunization of finance. These develops are also constitutionalized. And just to end with an example, Christie Grain, which is 1905, Justice Holmes, in that case, Justice Holmes adopts an approach to the market that can only be called neoclassical and deregulatory, despite some of his later work. He's awed, clearly awed by the power of the futures markets. And decision-making there to him seems legitimate. He says it's not gambling, rather speculation by competent men, is the way he puts it, produces the self-adjustment of society to the probable, which is, in his view, a beautiful thing. It is true, he admits, that the weak and the incompetent may be hurt, but legislatures and courts, and here I'm quoting, have generally recognized that the natural evolutions of a complex society, the futures market, right, are to be touched only with a very cautious hand. They should therefore resist coarse attempts at remedy for the waste incident to every social function. We have here a market defined as entrepreneurial activity for profit, naturalized, the futures market becomes the natural evolutions of a complex society and given autonomy, here as a phenomenon to be touched only with a very cautious hand. And that's all by, and as a, I guess I would say, an introduction to the 20th century.
Hello, can folks hear me? So first, I'd just like to say thank you to Maeve for that lovely introduction, to all the organizers, including Caitlin Walsh, and especially to Joey and Willy for their wonderful book. I feel like I've learned so much from both of you over the years, and it's really a pleasure to be here. And it's wonderful to be on this panel with both Christine and Lev. So I'm going to spend my time, and I might go a little bit more than 10 minutes. We were told we have a little bit of flexibility when it comes to time, by talking about the Socialist Party of America's account of constitutional political economy in the early part of the 20th century. And I think there's a value to discussing it because it highlights the fact that there was a debate that you can think of as on the left about how to think of the relationship between the Constitution and political economy. There was one version of the story which emphasized the idea that the goal was to redeem the constitutional project by infusing it with democratic accounts of the possibility inherent in political economy. So that's a redemptive story. And then there was a second story that the SPA really carried forward. And I think it's worth highlighting that the SPA was a significant political force. It had elected officials up and down levels of government, hundreds of them in the early part of the 20th century, one of the most charismatic politicians in the country, its leader, Eugene V. Debs. And their argument was that you should not redeem. Instead, you needed to fundamentally transform both the existing political economic system and the constitutional order as a matter of its basic institutions, but also symbolically through acts of rupture. And I think, spotlighting this debate is relevant for the present because effectively it's the same debate that we're having now. Now, there's lots of points of contact, I should say, between these camps. So this is not a question of a clear binary. There's a ton of overlap, but there are real differences of orientation that have distinct implications for how to think about the political process. What I'm going to do is kind of work through the socialist account of political economy. I'm going to go through their idea of how you should imagine what a constitution is, as well as how change should occur. So that's going to be the first two parts. Then I'm going to talk a little bit about what I see as really the central limitations of the socialist vision from the early 20th century, especially around questions of race and gender, as well as around the difficult, thorny issue of means, how do we get from here to there. And then I'll end with some very short reflections for the present. So for the SPA, the goal above all else was building a class-conscious majority of the working class that understood itself as committed to, in the words that Maeve used, overcoming capitalism, transforming an oppressive economic system, based on a background judgment about the society, which is the society is organized through fundamental conflicts, irreconcilable conflicts between those that enjoy economic power and those that do not have economic power. And they saw the Constitution as centrally tied to entrenching this system. They had a critique of the Constitution that was actually quite familiar then. It's familiar now. It's a critique of institutional design. The argument that they shared with many progressives, and that is very, it's commonplace in today's discussion, is that the Constitution was fundamentally undemocratic, that it fractured majority rule because it limited the power of the vote, and at the same time, through all of its various veto points, it facilitated minority rule. And that because of this, you couldn't think of the constitutional system, even before you get to the question of like the actual rights that are embedded in the system, the focus on negative liberties, you couldn't think of it as neutral in debates over political economy. That it essentially served to rig in the political process the kinds of outcomes that you'd end up seeing substantively to debates in economics, that these things were tied. This was a position broadly shared. The disagreement concerned to what extent these institutional defects could be remedied through kind of informal adaptation that held on to a basic reverence and veneration for the overarching constitutional system. So the progressive argument that eventually became the dominant New Deal position was that, you know what, it's a short document, its provisions are vague. If you can control the presidency, and through controlling the presidency, control the courts, then you can reinterpret this text. And by reinterpreting this text, you can actually infuse it with all the principles that you might want to back and support. And socialists had three different kinds of basic arguments in response. Argument number one was that the goal wasn't just what you can think of as technocratic fixes to the economy, creating a floor for wages, adjusting the questions of production and efficiency. The goal was once more power building, having an entrenched, sovereign, governing public that enjoyed the mass power to shift and alter existing relations in ways that broke from hierarchies at the time. And if that was the goal, then they were concerned, one, not just institutionally with the Constitution, but symbolically. So they argued that in Europe, well, how is it that aristocracy and feudalism was entrenched? It was also through symbols, symbols especially of crown, symbols especially of church. In the US, that's not how class deference was maintained. Class deference was maintained actually to the very symbols of republicanism, with the Constitution chief among them. That was because the Constitution wasn't just an abstract document, it was a concrete structure of authority. And to the extent that the public assumed that this constitutional order, this structural order, actually embodied we the people, they would genuflect before the very kinds of institutional arrangements that sustained rule by the few. And so you had to have a symbolic break, because otherwise you wouldn't develop the kind of class opposition that was necessary for building up a majority committed to meaningful transformation. That's a symbolic argument. Then there were two other arguments about how the call to redemption ended up sneaking back in a vision of neutrality. So argument number one was, yes, it's the case that the text is open-ended. There's a possibility for interpretive alterations. But the problem was that the rules of the game were rigged. And this is because, in a deep sense, the rules of the game in legal, in law and politics were tied to the rules of the game you can think of in political economy and capitalism. And they were rigged both in terms of the structure, but in terms of the distribution of power in society. And given that distribution, it was always going to be the case that the types of interpretation that were genuinely tied to emancipatory outcomes were far less likely to take place. And so that if you engaged exclusively in these internal battles over interpretation that assumed a redemptive constitution, you would almost inevitably end up on the losing side. Even in victory, you'd find yourself essentially enjoying the kind of jaws of defeat. And so you couldn't presume that the openness of the text would somehow overcome both the structural impediments, things like the Electoral College, the Senate, state-based representation, malapportionment, et cetera, the Supreme Court's unelected nature, et cetera. But also the fact that those structural impediments were embedded in a society that was itself fundamentally unjust. Then there was a second argument, which was, even if, let's say, it was possible through a kind of redemptive approach to move in the direction that you might want, there was a deep criticism of how mainstream progressives conceived of what a constitution is and how it related to political economy. They largely took, in their view, a technocratic approach. In other words, there was a problem of anti-democratic design. Along with changing interpretation, you should address these democratic defects. And by addressing the democratic defects, you create some new ideal set of legal political arrangements. This is what Sam Moyn and Ryan Dorfler called a vision of constitutionalism as fundamental law. The whole goal was to set up some new set of arrangements that existed as a higher law that could then constrain politics. It was still built on what you might think of as a distinction between process and substance. Your goal is to get to a point where there's some idealized process that's going to be overseen, if not by the courts, then maybe by the administrative state within the context of the presidency, and that would contain or limit political conflict. And their point was, no, this is not how you should think of what constitutionalism consists of. It shouldn't be a focus on constitutional law, it should be a focus on constitutional politics. And by that, they meant that the only way to ensure that a transformative majority actually wielded power in society was to have arrangements that were constantly open to experimentation and change. And that meant thinking about institutional forms that, like a simplified amendment process, a move toward parliamentarism, a text that looked more like a statute than like a constitutional document, but that was always part of a continual cycle of revision. And the reason why, according to Crystal Eastman, so significant socialist constitutional thinker during this period, was that so long as the political economy was organized on oppressive terms, and that the society was built through class rule, then you could not assume that you could have this idealized legal political process. These two things were linked. You could never distinguish between process and substance. And so you had to be in a continual process of change. It also meant that when they looked at reforms, they didn't distinguish necessarily between what we might think of as procedural adjustments, get rid of the Senate, and what you might think of as substantive policy changes, like, for instance, an 8-hour day or collective bargaining. They saw them all as reforms, non-reformist or revolutionary reforms that would make it harder for the existing landscape of institutional authority to reproduce itself, make it harder for the status quo to persist. And so what you're constantly looking for were tools that would build power for the social movement and the mobilized majority, and at the same time, make the political as well as the economic systems more adaptable and open to real transformative and continuing change. I should add one other thing, which is this did not mean that they were suspicious of rights, that socialists were some of the most consistent defenders of what we can think of as not just labor rights, but reproductive rights in the case of Crystal Eastman, and then of course, free speech rights and dissent rights. They view these as essential under conditions of capitalist hierarchy, but they also believed that the best way to protect rights was not through minority institutions, but was to the extent that these rights were understood as popularly grounded, the product of mass action and mass codification, a very different way of conceiving of how rights fit within a constitutional system. All right, so what do I see as some of the real limitations? Limitation number one is that this vision of a sovereign people had tremendous difficulty in conceiving of both questions around race, gender, and I should also add indigeneity. Now, socialists like Debs were absolutely committed to both racial equality as well as gender equality, but they had a theory of hierarchy that really emphasized class as a kind of universal category, in which to the extent that you had, for instance, I'll focus here very quickly on issues of race, you had racial oppression, it was very much understood as sublimated within the class story. Even the arguments about slavery, the extent to which slavery was a problem for the constitutional system, was to frame slavery as an issue of class rule from an earlier era. And what this did is it fundamentally ignored what was emerging among Black socialists at that time, Hubert Harrison, Du Bois, where they were saying that the model of capitalism that socialists were taking on board, white socialists, was one drawn from Europe in a way that ignored the extent to which capitalism in the US was a product both of the expropriation of indigenous land, as well as the use of enslaved and coerced labor as a condition for capitalist development and growth, and that you could not have a story about race that was itself not what today we call a story about racial capitalism. Crystal Eastman made very similar arguments about the gender division of labor and what today we would describe as patriarchy, and patriarchy's essential role in sustaining a system of capitalism. Now, in practice, this meant that while socialists, white socialists, emphasized the authoritarian dimensions of the existing constitutional structure, they ignored the central place in which white authoritarianism actually persisted, which is the politics after the Civil War in the late 19th, early 20th century, around the destruction and defeat of Reconstruction, which was through constitutional structures of minority rule that then facilitated the defeat of Reconstruction and then imposed a politics of white minority power in which anything like multiracial democracy was understood as an existential threat. And this, of course, ended up having really deleterious effects for reform traditions of economic democracy across the 20th century, where there was a continual tendency among socialists, progressives, and New Dealers to effectively separate the question of race from the question of social democracy. To imagine that you could pursue economic changes, and yes, there's a problem of segregation in the South, or segregated trade unions, or white supremacists within the labor and socialist camps. But if you got the economic changes, somehow the racial changes were kind of like after effect that would proceed in time. A tragic bind, basically, that the left faced across the century. The second issue is the question of means. And by means, what I'm speaking to is the fact that the SPA believed that if you just built the majority, then you'd have enough support through elections, through maybe an amendment process, maybe a convention, to get the outcome you want. You could move incrementally, but all you needed was essentially to have the vote, and then everything else would follow. There are folks in the IWW, more radicals in the labor movement, that said, well, wait a second, folks with power are not going to just give up power. There's all sorts of problems with the idea that elections will necessarily produce the ends that you want. And so they emphasize things like non-electoral strategies, the general strike, notions of direct action. But in a way, both sides of this debate had a significant problem. For folks in the IWW, there was a kind of millennial quality to the idea that there would be some great break that would produce a new world. For folks in the SPA, there was a refusal to confront the fact that, well, you might actually need to use means that are not established through process. Socialist politicians didn't want to talk about this because they were already being tarred as lawless, used to be able to sit in Congress or in the New York State Assembly. But there was a basic question of means. And this, I think, leads to the final thought that I apologize that I've gone long, which is, for now, I think both of those issues are actually really central issues for how we should think about constitutional politics in the present. One is, well, even small changes to constitutional structure, like DC as a state, or getting rid of the filibuster, or getting rid of the Electoral College, are unlikely to occur within the terms of the existing constitutional system. And it emphasizes the fact that the very same question about means is one that we have to reflect on, which is, how can you have an account of norm breaking that is ethical, that is grounded in democratic practice, that doesn't just produce tit-for-tat conflict, but appreciates the extent to which that's the kind of confrontation that we're seeing in the present. And then the second is how to have a politics that's not just class conscious, that's multiracial, that understands that working class politics is multiracial, and that building a transformative majority for a multiracial democracy requires centering issues not just of capitalism, but of racial capitalism. And these are the kinds of questions, I think, that the SPA requires us to engage with, and that pushes in a way beyond just the question of, can you redeem the constitutional project? And it also highlights a final point, which is the extent to which we're well beyond what judges in courtrooms or even officials in the executive branch actually think of as the relevant reform debate. That it requires having a constitutional conversation that is grounded in what would it mean to actually build a movement of a majority that could see itself as a constitutional actor in its own right, engaged in much more substantive change. Sorry for going on.
Thank you. I'm afraid after Aziz, my comments are going to feel a little less inspiring. Thank you to the organizers for inviting me, and to Maeve, and to Aziz and to Chris. It's a real privilege for me to be on this panel, in particular to be on the panel with Chris, whose work has inspired so much of my work, and from whom I've learned so much. Willy Forbath at the beginning was talking about how we sort of lost our tradition of constitutional political economy, but Chris never lost it and has been teaching, for decades now, constitutional political economy, law of money, constitutional law of money, and in some sense, I think that all the rest of us are catching up to where Chris has been for a while. So I thought I would situate separation of powers into this conversation, into the conversation about the Constitution and political economy. And it's not an obvious fit. So, I'm going to draw a little bit on money and public utility at points, but I want to try to make the argument that separation of powers really matters for political economy, our constitutional political economy, and that our current separation of powers is the understanding of the Constitution is much inferior in many respects to the American tradition. So today, a majority of the court routinely invoke the Constitution against various aspects of the administrative state. This isn't news to anybody. They harness a separation of powers theory that they claim is rooted in American constitutional tradition, so that sort of the lost constitution in exile. I think the reality is that their theory is not old at all, and that the Roberts Court is not engaged in recovery so much as fabrication. And its separation of powers theory was really built in large part over the last 40 years, and it was built by both Democrats and Republicans. The point of the theory was to bring about what Cass Sunstein in the 90s called American perestroika, namely deregulation, degradation of bureaucratic capacity in federal agencies, and centralization of policymaking power in the federal government in the White House. So that we now have a more extreme version that's in vogue today. Unitary executive theory uses Article 2 to sort of prevent Congress from shielding certain government functions from the president, from partisan politics. It seeks to constrain the ability of legislators to harness expertise. It diminishes state capacity. In the form of the major questions doctrine, separation of powers is also being wielded as a sort of interpretive presumption against efforts by Congress to empower administrative agencies to solve public problems. And so it's wounding legislation that was passed with the expectation that judges would interpret the text using very different interpretive principles. I think this stands in stark contrast to the actual American constitutional tradition, which was much more anti-oligarchic in orientation. And in this sense, it's not just arguments that were anti-oligarchic, but the actual doctrines and understandings of American legal practitioners from the founding more or less to the late 20th century was very different from how the Roberts Court is conceiving of separation of powers today. That tradition put Congress and legislative power at the center of the federal government. So the president was not to be the nation's chief policymaker, Congress was. The president's role was to take care that the laws are faithfully executed. As Justice Holmes explained in dissent in Myers, the president's constitutional duty to do so went no further than the law and what the law saw fit to leave within the president's power. Congress, meanwhile, was understood to be able to delegate in a wide variety of ways. The Constitution was an enabling document. It established three constitutional actors, And it was Congress's job to fill out the details of government with its ongoing lawmaking power. And so Congress could create offices of all shapes and sizes. It could delegate to corporate instrumentalities, either nonprofit or for-profit. In this way, the Democratic policy could craft a government capable of solving complex governance challenges around the structure of the economy. And we can see this right from the founding. So you get the Bank of the United States. It's explicitly conceptualized as a delegation of public power to a private corporation, or to a corporation to be controlled by private investors. Hamilton thinks that this sort of hybrid governance is the best way to expand the money supply without jeopardizing confidence in the currency or incentivizing future government corruption. And the bank is attacked on many constitutional grounds, but none of them sounded in the separation of powers. So Chris referred to Jackson's attack, and it was about the special privileges that were being dispensed to certain shareholders. But nobody said that Congress lacked the authority to delegate such a core public function as money augmentation to private investors. Even Jackson accepted that under different terms. No one said Article 2 prohibited Congress from insulating the bank's directors from presidential removal. The bank was really our first independent agency, and it was understood to be constitutional. Other scholars have looked at other areas. Nick Perillo has shown in the tax space, Congress carefully constructed administrative structures. He has a pair of papers about the direct tax of 1798, shows how Congress delegated broad powers to administrators. And Congress imposed restrictions on presidential appointments. Alexia Chabot has a paper about the Sinking Fund Commission, which was an early executive body for buying back Treasury debt that had the Chief Justice of the Supreme Court and the Vice President on it, 2 officers of the United States who could not be removed by the President for any reason. It was natural that early experimentation at the federal level would be largely in the fiscal realm, the bank, the tax, the fund commission. When the federal state turns to more actively regulate national commerce at the end of the 19th century, you see a flowering of other institutional design. So you have public utility regulation emerge at the federal level. And at its heart, this is an effort to preserve and sustain Republican democracy. And it relies on legislative power. It depends on a distinct separation of powers understanding. So take Brandeis, for example, which Fishkin and Forbath talk about in their book. Brandeis's democratic theory of the Constitution animated not just his First and Fifth Amendment jurisprudence, but also how he understood the constitutional relationship between the branches. So Fishkin and Forbath say, Brandeis wanted a judiciary that, quote, had respect for the policymaking capacities of legislatures and administrators. And they call this Brandeis's legislative constitutionalism. So part of what's gone wrong, I think, in our political economy over the last 50 years has to do with the decline of legislative constitutionalism. And I think there's a question, what happened? And I will just briefly sort of sketch out my view as a provocation, which is that statutes are sticky, and the New Deal statutes were entrenched and protected by a Democratic majority in the House of Representatives. Opponents of public utility regulation, structural antitrust, health, safety, and environmental regulation saw that there were limits to how much they could achieve through the legislative process in their effort to repeal these statutes and pare them back. And so they started building a separation of powers theory that put the president at the center of the administrative state, that gave the president constitutional authority over administration, first as a default under the sort of presidential administration view, and later as a requirement under the unitary executive theory view. To underwrite this process, initially there was an embrace and a creation of what's called Chevron deference, which was designed to give administrators flexibility to deviate from New Deal statutory frameworks. More recently, as bipartisan consensus around sort of neoliberal governance has eroded, the court has invented a new interpretive theory derived from separation of powers, theory that requires Congress to clearly delegate powers it wants the judiciary to enforce. And so I think that, in the spirit of recovering our constitutional past, we can better understand how novel and radical these ideas are, and also how dangerous they can be to the project of sustaining democracy over time. I think that if we stand any chance of rebuilding a sort of egalitarian political economy, we have to combat a vision of the separation of powers that would hobble legislation and undermine administrative government.
So thank you for all those wonderful panels. Before we open it up to the audience for questions, I wanted to just try to tease out where the panel ultimately comes down on this last question that we were asked to engage with, which is, does the history offer us lessons of ideological, imaginative resources that we should put to work today, forgotten tradition, or is this a history of cautionary tales in which we might be inclined to be more skeptical of reviving a lost tradition? And so I would love to just hear from the panels a one-liner of, or more, if you want to expound upon it. Is this a history that we should be seeking to recover and repeat, or is this a history of cautionary tales, or some combination of both? I'm struck sort of in tracing the path that we followed here on the panel. We hear sort of a moment in the 19th century where the arguments were, if not inevitable, but hardly surprising, right? You started off, how could they not be discussing this in constitutional terms? So is it just that it's an artifact of a particular time? Chris, as you were describing, it's not so much a liberal forgetting of a lost tradition, but rather a real shift in underlying structures that may make that language, that mode of constitutional discourse just of another era. And yet then we hear right in the heels of this from Aziz that no, there was a group that was willing to respond to that rise of judicial policing with a set of imaginative arguments that yet held within it the central limitation of an idea of a universal class that made it subsume other ideals of generating, moving away from hierarchical structures. And then Lev, lastly, we hear from you that actually what's happened is more of an internalist account in which the reason why we're stuck with where we are has more to do with the stickiness of statutes in a court that's willing to rein in legislative roles. So piecing, is that an apt summary of where we've been in our survey of the constitutional history of political economy? And ultimately, where do you come down? Is this a history to be revived or a history to be skeptical of? And then I'll turn to you, and then everyone can jump in with their own questions.
I'll just say briefly that by saying I think there was a structural change, I didn't mean that that structural change meant that constitutional discourse was no longer relevant, right? I meant that it was harder because it seemed to divide the economic from the political in ways that were not just ideological, but actually structural. So I would, sort of bring my remarks full circle to Lev's. I think part of what's going on is, or that we can't write the history he's writing, which sounds really powerful to me, that the context for that history is the rise of economics as a discipline that appears to dictate imperatives about the way we organize society and social relations. And that when you add that in, it contextualizes Lev's arguments in a way that I think makes quite a seamless picture.
So, for me, it's really clearly both. So first, I just want to say that I think the thing that's absolutely essential to recover, and I feel like has become increasingly part of the conversation, is something that's shared across the binary that I presented. Shared by folks that wanted a constitutional political economy that redeems the Constitution and wanted one that was a fundamental break and created some kind of new constitutional system, symbolically and institutionally. And this was a rejection of what amounted to the mode of constitutional law that developed in the United States, which is one in which constitutional politics is funneled to the courts. The courts end up then overseeing what amounts to the relevant reform conversation. And to the extent that ideas about the Constitution are viewed as part of the broader political debate, it's already essentially distilled by whatever it is that judges and lawyers think is important. And this, I think, was a fundamental limitation of the broader Cold War kind of liberal imagination that we've been left with, where essentially you have, actors of the state committed to a very limited range of perspectives, even before the full-on right-wing takeover of the court, that determine in advance what counts as a relevant reform debate. And all of these perspectives from the early part of the 20th century said that constitutional politics had to be removed from these centers of power so that you could have a much broader conversation about institutional design, about the basic organization of state and economy in ways that are actually consistent with what the national crises are. So you don't have a situation 100 years later, to use the example of race, where the only question of race that ends up emerging in the courts is affirmative action. Meanwhile, we live under circumstances of sustained structural racial hierarchy as embedded in our carceral state. But there's, let's say, a caution that I think you can draw from both perspectives. I think from the perspective about redemption, to me, the caution is the way in which it can produce a kind of divided liberal mind. On the one hand, there's this clear recognition that the institutions don't work. The institutions don't actually produce the type of political economy that one would want. And that there's, all of the sense that it's a fundamentally undemocratic order that produces somebody like Trump. But on the other hand, anytime there's a discussion about constitutional rupture, the immediate response is, oh my God, we need this constitution to protect us from Trump. And so that veneration becomes the go-to because it's so deeply embedded in a kind of redemptive story. And that internal contradiction provides us no way out of the present. So to me, that's like the big caution. For the ruptural story that I associate with the SPA, I think alongside the questions of race and gender and how to actually build something like a transformative majority that can understand and integrate a variety of oppressions, there's also the basic question of means, which is, at the end of the day, to generate the kind of transformative change, let's say, I would want, it's probably not going to take place through explicitly following procedural regularity. That's not the story of Reconstruction. It's certainly not the story of the founding of the United States. It's not the story even of the New Deal. And that requires really hard questions about how to conceive of what Weber would call an ethics of political responsibility. Like, what would be the ethics of imagining revolutionary norm breaking in ways that actually promote the kind of society that you want? If we were to have a convention, it's not going to follow the Article 5 process because of all of the ways in which that sustains state-based representation and facilitates control by a minority coalition. Even more minor changes will require ruptures. And this is something that I think folks on the left have tended to avoid by either kind of deifying the idea of direct action outside of the electoral process, or just imagining, I fell prey to this too, that like if you elect the right person, then somehow you'll have party realignment, or you'll just be able to create the majority that'll instantiate the policies that you want. And that is the pragmatic political question of the present.
My comments were really about a slice of the history of constitutional political economy, and a slice in which you can see that traditional approaches and understandings of the Constitution actually supported the efforts of progressive reformers to reform political economy. But I don't mean to say that on the whole the Constitution has been a force for progressive political economy, and I feel like it's above my pay grade to sort of weigh that slice against all of the other slices, which I leave to Aziz and Chris and others to sort of trade off.
Well, so before we open it up to questions, Professor Forbath, I just wanted to give you the opportunity to respond and reflect on any of these terrific comments.
I'll try to be very terse. And first of all, I'm enormously excited and grateful for these comments and the work of all four of you in this space. Aziz won't be surprised by what I say, but what I have to say is I think it's possible to exaggerate the grip of veneration. And one can take and how much it's how fruitful it is always to regard the contrast between veneration and debunking and rupture as a fundamental one, when so often, just to take the period that Aziz was talking about, these are for many, many figures from sort of in the socialist camp and beyond to the left and figures in the center, you can find them walking both sides of that street. And I think we may need to as well. I pushed Aziz to talk more about rupture, be less reticent, and to think hard about the ethics of embracing it. Those seem to me, so Aziz knows that we are on the same page in pondering that. How can we, those of us who are socialists, those of us who are sort of at the edges of progressive reform, think about the kind of fundamental changes we need at once to the economy and to the polity, without thinking seriously about rupture. I thought it was an irony that in some ways much more establishmentarian constitutionalists like Ackerman and Amar think harder about rupture than those of us who fancy we're on their left. So I couldn't agree more about the urgency of thinking about deep structural change outside Article 5. And it's, and again, Columbia, as it's a hub of neo-Brandeisianism, is also a hub of creative thinking about loosening up the seemingly rigid bounds against fundamental change. So I am on board with that. I tend to think that one needs creedal narratives, not about the structures of the Constitution, but about the principles at their heart, and that there are many imaginative and ideological resources within the mainstream of our constitutional history that can support those kinds of stories, right? The apple and the silver frame, the Constitution was made for the principles and not the other way around. There are millions such tropes. And so too, debunking and taking down the Constitution has its place too. One found people like Charles Beard on different days invoking the fathers, to ratify his vision of a workers' republic, and the next day in revering the fathers for handing down an instrument that was pliable enough to work within it. I think some of these issues are sort of situational. As for the sort of longue durée of economics supplanting political economy, I defer to Chris and to Lev, and I thank you all.
And with that, we'll open it up for questions. Yeah.
I have questions about the institutional foundations of property rights in the United States. And number one is the 1623 or 1624 writing by William Bradford called of the Plymouth Foundation, I think. And he wrote about the debate that they had after arriving on the Mayflower, I think in 1621 or 1622, regarding property rights. Should it be communal right or should it be held by individuals? And they decided to be individually owned. And he even said that crop production was very productive and everybody was happy and stuff. And I think that's one source of constitutional political economy as a start. The second two actions were, number one, the 1776 plan of 1776, which was about treaties, but also protected property rights during the Revolutionary War, and the Annapolis Convention of 1786, which ultimately led to the convention in Philadelphia. So how do you see those relationships in the history of political economy? Thank you.
I suppose as the resident colonial historian, I'll field this one, but then I'll just open it to others. So I think that this question beautifully tees up one of the central questions of how we study political economy, because it goes to a methodological rupture between the political economy as understood through institutions of public law, as institutions through public documents, in relationship to what we might think of as the world of private law, the common law, property. And so the moments that you've pointed at the beginning of the process of colonization and then the upset, the moment of rupture from the British Empire, are both moments that you could read through a history untethered from the material world of who owns property and who owns land and who owns labor. You could tell that story as an exercise of political institutions in which the argument is going to be, how do we design a constitutional structure that will allocate and solve questions of inequality? And the arguments that can be put forward might be symbolic, they might be material, but the lens through which we would be answering those questions will hinge on the political discourse of political institutions. And the two moments that you've teed up for us here invite us to think about what it would look like to tell the story starting from the baseline question of property rights, of a world of private law that's absolutely working in tandem with political institutions, but that preceded and shaped those institutions. So in my own work, my answer would be that work of settling and establishing a set of property rights was the sort of the seed crystal by which people began to imagine what type of public political institutions should be grafted on top, so that the ways in which people understood initial allocations of wealth was fundamental to then understanding how we might imagine what something called a sovereign state is, or an assembly, to get back to Chris's point, derivative of an initial allocation at a time when questions of sovereignty were up for debate, at a time when people had competing understandings of what we might think about as a colony, at the time where territorial borders were uncertain, immense uncertainty as to what we think of as our rigid political institutions, and which questions of initial allocations of property is going to be doing much of the substantive work. I don't know if others want to weigh in on the question, but yeah.
I have a question about, it's slightly different from the topic of the panel, but it uses the same words, just rearranged. So the panel is about lessons from constitutional history, and I'm interested to hear from all of you about how should we think about the role that history plays in constitutional discourse. Because I think that there is an interesting sort of implicit theory here that we're starting the day with a discussion about history and placing history central to the conversation today about the meaning and future of the Constitution. And it strikes me as both a positive and a negative, the strong role that history plays. I mean, if we think about the sort of historical idea of what a constitution is, it's a document that preserves, that maintains, that re-establishes, right? It is founded on a notion of history that is also is effective as a discourse for change. And this duality that you're invoking history often in the name of making change seems really powerful, but also for progressives who are all about the future, not the past. Is there a danger to tying oneself to a constitutional discourse, to a discourse that is so grounded in notions of history?
So I think that's, you folks hear me, I can tell if this is on or not. Can folks hear me now? Okay. How about this? Yeah, okay. Have folks been able to hear me? Now I have this like sense that I've just been talking into a void. So I think that's a really important question. So for me, the reason why I think the history is significant is because the story really of the long 20th century is one in which a variety of ways of imagining constitutionalism, little c constitutionalism, both globally, but then especially in the US, that sort of come up already at the table that's there in Willy and Joy's work, basically became narrowed to a very specific idea of American Cold War liberal constitutionalism. The Constitution as something that stands above ordinary democracy, that's where the court kind of protects minority rights from a public, and that the central constitutional predicament is really the problem of majority tyranny. I mean, this is all of the stuff that Americans, if you grew up in the US, is familiar. So it's like one way of thinking about constitutionalism. And honestly, I think the value of an historical analysis is just to expand constitutional memory, to recognize that this is one of many, and then also to alter who gets to be the repository of constitutional memory. So it should not be, frankly, the field that I'm a part of, constitutional law. It makes no sense that people that primarily work in doctrinal legal cases should be the determiners of the broad range of perspectives about what a constitutional system should be. That was not even the case 100 years ago in the academy, where the primary place where you studied the Constitution was in political science and history departments and sociologists, because the whole idea was that there was an intricate network of institutions that are part of what it means to have something like a flourishing democracy. So that to me is the value of the history, a shift in memory and a broader transformation of what counts as constitutionalism. But here's the problem, which is it's not a surprise that in a society that over the course of the 20th century increasingly venerated a very specific account of constitutional law, that history, when it comes to talking about the Constitution, would then also become most closely identified with what's emerged as a method, namely originalism. That the entire brand, regardless of whether or not you're an originalist, but the entire brand of mainstream con law that thinks about history is a mode of founders' veneration. So, even folks that are progressive, where it's about like, there were moments of rupture and we have to think about like what that new constitutional moment was that was created, that is a brand of founders worship. And what ends up happening over time is then you have an historical analysis that's always about, well, let's go back to some previous period in which there was an heroic set of founders that were able to establish an ideal set of institutions, or even if they weren't ideal, the way that we get change is by replicating what they did. And all of this is to produce an historical culture that is trapped in the past, and that's especially destructive in a present in which the society is marked by a plethora of sustained social crises. Crises to the institutions, crises to our cultural life, crises to the way in which we're able to relate to each other, and yet the way that we talk about constitutions is by invoking a past that has failed us in the present. So this is both to say, we need to have a very different historical imagination in order to be able to think meaningfully about the future, but the historical imagination that constitutional law as a field has built, even if you are not an originalist, originalism is only the most extreme version, is one that is devoid of the types of resources that allow us to recognize that the problem of the present is actually overcoming the sustained failures of the past. Or as many activists have said, the country has never been a democracy, so going back to the past for lessons about how to build a democracy is necessarily a flawed approach.
I guess I would just add, for me at least, history is doing two things. One, it's a response in some sense. So history, as Aziz was talking about, is invoked against the administrative state. It's invoked by the court, and it's important not to be gaslit by fabricated history. And so some amount of response, I think, is worthwhile. There's such thing as too much response to, getting captured into certain lines of debate that are counterproductive. And so I think you can go too far, but I think at least correcting the historical narrative, there's a function for that. Similarly, economics often asserts that there's no other way to organize the economy than as consistent with its theories, and history actually tells us that's not so. And so you can look back to the 20th century, you see you had a very different monetary and banking system that actually worked extremely well. That economics theory would tell us that doesn't make any sense, not possible. And in economics debate, there's very little understanding of a lot of that history. And so bringing the history back in, it sort of serves as a corrective. Again, there's like a limit to how much you want to get trapped into how we did money and banking in the 19th century. Lots of problems with that. And so you don't want to totally valorize it, but it serves, I think, it shows us that there are other ways. So sort of broadening of the mind. I think there's a sort of a second use for history. This is outside of the constitutional context, which is that history is needed to engineer policy. So, I agree, progressive look forward, but the only way to think about the future is to understand the past. And policy making at its best is really an empirical exercise. and it's fueled on experience. And I think, you know, Brandeis, for example, recognizes he was an empiricist, and history is an empirical enterprise. And so I don't think it's really possible to chart a future without knowing where we've been and what we can learn from that.
So can I just add, I think this is completely in line with what Aziz and Lev said. For me, it's a radically denaturalizing method that I'm always struck by the fact that we have premises we don't even know to question, right? And for me, that's why money's been such an absorbing task, right? To come to the realization that banks play a role in creating new money and in allocating credit. When you actually understand what that means, you also realize that, you know, we talk about Reconstruction without talking about the financial choices that crushed Reconstruction. And the financial harms that came from it. So just one quick example, right? If you don't ask about banking and how banks work, you don't realize that what the federal government did was delegate to private actors really full control of the way credit would be allocated at the same moment that the Supreme Court immunized private actors as outside of state action, so that discrimination by banks in allocating credit would become just the norm of the 20th century. So that, you know, that kind of thing we won't even see. And, you know, given the premises we have about that's just the way the economy works, or that's just the way money works. So for me, it's eye-opening in that sense.
Back to the, I second everything.
Thank you so much. Building on that, I have a question about Reconstruction also, which is if there is a failure of imagination of the socialist critique of constitutional structures to fully conceptualize the meaning of the utter failure of Reconstruction, were there contemporary critics who were centralizing the rise of white authoritarianism in the wake of Reconstruction's failure, who made different critiques about the Constitution and the ways in which those structures, like to what extent did they overlap or differ for critics of the Constitution enabling the failure of Reconstruction with the critiques that were focused more on class and capital?
So I can just jump in quickly. I mean, I think that these are the arguments of a long tradition of Black socialists, including people that were members of the Socialist Party, ended up breaking from it. So in particular, Hubert Harrison, Du Bois, A. Philip Randolph, in the teens, 20s, and 30s, all three were essentially making arguments about the limitations of SPA thinking around Reconstruction and then around racial capitalism. So yeah, okay, I'll use both mics. So the Hubert Harrison's point was that there was a reason why capitalism was organized on racial grounds, and that was because of the very clear legacy of slavery as central to the reproduction of capitalism, and then white planter resistance in defeating Reconstruction. And that meant that if folks in the SPA were actually committed to building a true party of the working class that was multiracial, then they would have to organize Black workers. And that meant that they would have to center the overcoming of Jim Crow practices in the South. They couldn't see this as like a side issue. And it also means that they would have to take very seriously the structure of state-based representation. So one of the things that happened with white populist progressives and even socialists is that at the state level, you had all of this like incipient economic populist energy that was organized in white political spaces. And so there was a de-emphasis on thinking of like the state as necessarily something that should be broken. But Black socialists argued that you had to make sure that Black people had the right to vote, you had to organize Black workers in the South, and then you had to think really seriously about breaking up the state system. So one of the classic expressions of this is the Black Belt thesis that communists like Harry Haywood ended up developing in the 20s and 30s. Today, we tend to think, oh, the Black Belt thesis is this crazy idea that like that there's going to be a separate independent state for Black people in the South. It was part of the sustained conversation about, well, there needs to be some kind of mechanism to ensure that you had Black political representation. And the argument was not an independent polity, but was different forms of majority instruments that would go across basically Virginia to Texas by altering the nature of the state system. And these were all of the ideas that were part of basically the Black socialist imagination. And I should say, they were written out of the socialist record, and they were written out of our contemporary constitutional record. We don't think of Du Bois as a constitutional scholar, despite the fact that his most significant book is a book on Reconstruction. And we certainly don't think of Harry Haywood or Hubert Harrison or A. Philip Randolph or Ida B. Wells, and I could go on and on, as significant constitutional thinkers that were attempting to center the question of racial capitalism and how you alter the institutional form of the American state.
Do you have time?
I guess I was wondering if someone could speak a little bit to like the internationalist sort of perspective, and in terms of like, you know, I think there's a sort of American exceptionalism where the U.S. sees its own constitution as so somehow unique that it can only really look to its own traditions and its own history. But I feel like there's a really rich history if you look to the Caribbean, to certainly a lot of decolonized or like you know, new republics throughout the course of the 20th century. And I'm wondering if any, I guess if you see anything there in terms of how that can sort of destabilize our sense of what the Constitution means in the American context, and or if you think that there is a movement towards bringing those kinds of critiques in.
Should I jump in again? So, I mean, I think this is really important. The one way that I'd say this is that in the time period that I was discussing, so the first 2 decades of the 20th century, yeah. In the time period that I was discussing, the first 2 decades of the 20th century, in many ways, the most significant constitutional project was the 1917 Mexican Constitution, which ended up having a massive effect on how Latin American countries conceived of constitutional possibility. It influenced the Weimar Republic. It shaped kind of the broader social democratic imagination. And if you look at labor and socialist journals from the period, they're interested in what's going on in Mexico. And it's because their perspective is explicitly internationalist, which is that the problem of labor is a global problem that's tied to capitalism, and that the way in which you build a transformative project is to have these internationalist alliances and to draw from what's happening elsewhere. The story, I think, of the first half of the 20th century was to systematically shut down these approaches. There's a lot of reasons behind this. I would put the US's emergence as a global superpower from the Spanish-American War to World War II, and the centrality of a very specific account of constitutionalism that you can associate with Cold War constitutionalism as both justifying that power and as shaping the terms of what counts as an appropriate reform imagination at home, that transformed the American brand not just into like the only way Americans think about the Constitution, but as like the ideal type for all modes of constitutional politics. And I think really where we are today is grappling with this strange contradiction that we've spent basically the last 75 years venerating a text as the near ideal distillation of democracy that is in fact one of the most dysfunctional examples of how to organize a meaningful democracy. And that, so we're stuck with this contradiction, and we're now forced to kind of recognize that in the plethora of crises that the country's facing, that all of those models that were rejected frankly because they were not coming from the global north oftentimes, are perhaps much more vital and relevant for thinking about how you'd want to build a social democracy than the one that we have.
So quickly, to sort of simply riff for just half a minute on what Aziz just said, if one gets deeper into the two constitutions he mentioned as instances of 20th century socialist constitutional imagination, one finds a striking contrast between them and the sort of post-colonial late 20th century constitutions that we often look to. So one looks to South Africa, one looks to other countries with rich sort of social and economic rights provisions in their sort of up-to-date constitutions, and one thinks, would that be where we could go? That wasn't, right, Weimar or Mexico. The constitutional imagination one finds afoot there is much more, to my mind, promising than, apex constitutional courts elaborating social and economic rights provisions. What one finds there is efforts to create blueprints for participatory forms of both industry and agriculture, so that one finds in Mexico, very sophisticated ideas, both in the Constitution itself and surrounding it, about land ownership that is neither sort of individualistic nor purely collectivist, but some interesting hybrids of participation and sharing. And in the Weimar case, all kinds of imagined sort of workers' councils at every level of economic life. So again, the effort to constitute a participatory and more democratic sort of form of economic life was in many ways more relevant to how we think today, having grown somewhat disillusioned with apex courts and what they can do in respect of inequality.
Can I say something that's a little different, maybe a little less optimistic, which is just, there's also a small c constitutional dimension of your question. That is, I look at, the institutions I study are globalizing from the 17th century on. So the spread of central banks, the spread of commercial banks, the spread of public debt, the spread of capital markets, that's also a really fruitful way to think constitutionally and to see how those institutions travel and how they morph, and how we now have to look abroad for various initiatives about how to revise them. So the Bridgetown Initiative on Public Debt is a really interesting, innovation, which is, in part a response to the extractive nature of public debt at the global level. So it's not a happy story necessarily, but it is a story that directs our attention to the travel of institutions that may have started parochially, but change as they travel globally, and we should attend to the possibilities created by the change.
And with that, that brings us to our end of our panel. So please join me in thanking our panelists for their terrific comments.
Okay, it's just, I think the mics are a bit hit and miss, but this seems to be working. So welcome to the second panel. This is, so we're going to sort of structure this slightly differently, which is that rather than have any sort of opening remarks or presentations, it's going to be a little bit more of a Q&A, largely to sort of give myself more importance. And I did want to say that Reva Siegel sadly can't join us, so apologies for that. And I think part of what's interesting about everybody on this panel is that they think about constitutional law, but they also think about constitutional politics. And so the hope of this panel is to actually get us to sort of move a little bit out of the historical, or maybe like, even just out of the world of just ideas, qua ideas, and to actually think a little bit about what it means to put political economy back in the domain of constitutional politics. And so some of the sort of questions that I'll be posing, or that we together be thinking about, are about sort of how we should think about really what are the good and bad things or promises and perils of actually connecting these two domains. There was a lot that was said in the first panel about how these two domains were maybe not true, how they had a lot of sort of dualities, but also mutualities in historical periods. And just as a matter of changing things on the ground, what does it mean for liberals and progressives to actually sort of work with these kinds of arguments? Does it even make sense to do so, given the current composition of the Supreme Court, given that we live in a country with judicial supremacy? Is it really now constitutional political economy that we should be seeking, rather than just thinking more about political economy within the domain of the political? So this is just sort of, it's kind of going to be hopefully a little bit think aloud and interactive. I'm not going to sort of introduce everybody, because you do know them. But I'm going to begin with Ash, and I think Ash, one of the things that I think it would be great just to begin speaking about it just at a basic elementary level. How should we understand the promise and perils of connecting the Constitution with political economy, and what do we gain and lose as liberals and as progressives from sort of thinking about politics in this particular way?
Great. I'm excited to be here. I just sort of, the informal nature of this, I don't think should preclude the sort of preliminary thanks. I just wanted to flag two people, Caitlin and Avita. Sort of other than Santa Claus, very few people produce more joy from behind the scenes. So just extraordinarily good at their jobs. So we're interested here in political economy and its relation to constitutional theory and constitutional politics. And the major works in this area, like Joey and Willy's, have presented, how they've presented things is that we're interested in something called constitutional political economy. And on their view, and many of the views you'll get in that vein of thought, constitutional political economy is something like making claims about political economy in a constitutional register. That's just as a preliminary working definition. I want to contrast that tradition, which Joey and Willy have shown us is very old, with an equally distinguished tradition, which, for now, one might call the political economy of the Constitution. We've seen some examples of this. Indeed, the first panel, I think, was exemplary in this, and you didn't plan it that way, but the invisible hand apparently did, so thank you. From Christine and Lev and Maeve's preliminaries to Aziz's discussion of the socialists, this tradition, which also includes folks like Charles and Mary Beard or Louis Boudin, the question they're asking is related but different. What sort of political economy does the Constitution, as it exists at any particular point in time, both the document and the doctrine, build? Like, what is the bent of that document? In Europe, you might, continental theorists call that the material constitution, and it's a very familiar tradition there. So Beard could look, for instance, at the structures of the Constitution and the material interests of its framers, and reach conclusions about the political economy they sought to achieve, however fitfully or unsuccessfully. Politics often has its own rhythms and reason. So when you take these two traditions that I've drawn and you put them in dialogue, I think it's a productive way to think about it, constitutional political economy versus the political economy of the Constitution, because it relates to Madhav's question about the promise and peril, which is also the title of this panel, because it attunes us to different important differences in these two traditions. So constitutional political economy, for instance, often revolves around the rhetorical and political pull of the Constitution as a language for talking about and doing politics. And some of its attractions lie in the way it asks us to make demands of the state, in particular in their account of the legislature and in others of courts, whether it's in the form of statutes or in the forms of rights claims. The political economy of the Constitution, however, asks us to do something different. And this enterprise is often more contingent, case-specific, granular, frequently speculative, and unstable, but nonetheless extremely productive and material, pun intended. Namely, identify the ways the Constitution, very often its structural features, but in certain domains rights, interacts with the current array of political and material interests to produce certain sets of political outcomes. And for us, this means, for instance, grappling with the interaction of the Senate or the Electoral College, but with particular demographic facts about which constituencies actually end up having power under these particular arrangements. And so if you buy this distinction, and there are inevitable overlaps, that happen when you do this sort of distinction making, then I just want to suggest two things that might be helpful for subsequent discussion. The first is sometimes constitutional political economy and the political economy of the Constitution will be in tension. Given the current court and the array of doctrines that have been built over the last 4 decades, the political economy of the Constitution might counsel away from constitutional arguments altogether, or at least see constitutional political economy's attachment to language as perhaps less important than attunements to power. Not that these things are mutually exclusive. It's a question of emphasis. It also provokes a more fundamental question that I think is quite important for thinking about constitutional political economy, which is, what does layering constitutional on top of political economy do for us? Especially when it comes to legislative claims. Does it discipline the court, for instance? Does it add further poignancy and political jet fuel to the sorts of claims we're making? Or might it be doing something more insidious, like entrenching a sort of veneration that most of us at our most charitable seem quite ambivalent about at the moment? And the second point is the distinction might also suggest some hesitation about a comprehensive vision of the Constitution as securing particular things or securing particular outcomes, and instead a rather more issue-specific and piecemeal approach towards solving our problems. Pragmatic, you might call it. We might, as others like on this panel, Dave in his work on structural biases in structural constitutional law, or Genevieve in her work on the First Amendment, search for a more egalitarian First Amendment, or see structural change through legislation, or a coherent theory of representation and democracy in election law as a bigger priority than perhaps a meta-narrative of the Constitution. We might eventually reach that meta story, that overarching story, issue by issue, a sort of common law route to comprehensive constitutional political economy. But I think the framing of constitutional political economy versus the political economy of the Constitution might be helpful for thinking about why there's such intramural and I think really fruitful debate about the promise and perils of constitutional political economy.
Great, thanks, Ash. That sort of sets us up beautifully. Genevieve, I sort of, not to make this too sequential in that way, but I did actually want to come to you next, regardless of where you were sitting, which is just to sort of take off from Ash's last point. What are the forms in which you think liberals and progressives actually need to make sort of rival arguments? Because one of the things about the right and about the conservative majority is that in a way and this sort of also became clear earlier, right? They've wonderfully constitutionalized political economy, and it's not clear what the response could take many forms.
Thank you. And again, thanks to the organizers for inviting me. This is a really fun and interesting conversation so far. I'm very happy to be here. So I'm going to answer your question, but I think I'm also just going to answer the earlier question you posed, because I wanted to pick up on what Ash said in a multitude of ways, because I was thinking about the promise and peril, the topic of the panel. And I was enjoying the fact that in this panel, we're supposed to talk about the good and the bad, that there's a kind of deep ambivalence or uncertainty sort of constructed into the panel, which I think sort of pervades this day. Like, there were a bunch of progressives come around to talk about constitutional political economy, and we're like, I don't know, seems good, seems bad, complicated. Oh, sorry, is that better? And I myself feel a lot of ambivalence about this question of constitutional political economy for reasons I'll say in a second. And I think a lot of progressives do. But that's complicated because ambivalence does not seem like the ideal political emotion to possess to generate wide-scale political change. You know, you do it, maybe. Does not seem like the most motivating sentiment. And so I thought the morning panel and Aziz's comments in particular were useful for thinking, for allowing me to think about how ambivalence could in fact be used productively to think in a more nuanced way about what are the kinds of reforms or movements we want to embrace in a more full-throated manner that generate out of ambivalence. But just ambivalence. So I think, like Ash, feel these two prongs of these two ways of thinking about how we think about constitutional political economy, the good and the bad, very powerfully. So to answer your question you actually posed to me, I mean, I guess I will say that I don't think constitutional political economy is just using constitutional language to talk about political economy. I think that there is no other way to think about rights than through a political economic lens. I'll just say it's just correct. Like there's, when we think about rights, when we think that someone has a right to engage in free speech, or they have a right of equality against the government, I think there's no way to understand that in kind of any meaningful way without thinking about the material conditions in which they live, without thinking about the economic and political forms of inequality in which these rights are exercised, without thinking about the sort of the real stuff of society that enables but also constrains the ability to exercise its rights. I think a vision of the Constitution that is not informed by a political economic understanding of hierarchy and materiality and economics is just a crappy vision. It's just a bad vision. That a formalist conception of rights, a formalist conception of equality does not vindicate the interests and values that we invoke when we talk about the rights. Like who cares about free speech if it's just the right to speak to the pigeons under the bridge, right? So on the one hand, it seems absolutely just correct when we're thinking about the Enlightenment tradition, the sort of utopian idea of democracy, an idea of a self-governing society, whatever that might mean, and the idea of self-governing individuals, whatever that might mean, understanding these as both high ideals that are somewhat unfleshed out, that we are trying to figure out what they might mean and what are the kinds of privileges and rights that one must possess in order to live in this way in the world with others. It seems impossible to imagine a constitutional discourse that is bereft of political economic thinking. It's just bad. It's just bad thinking. This is my strong view. So on the one hand, like I'm fully on board this idea that we should constitutionalize or political economize our constitutional discourse because it just seems better. This is the law professor part of me. But on the other hand, there are the federal constitution, if we're thinking about the constitution in those terms, is a deeply problematic document. And although that emerges at a time of strong counter-revolutionary sentiments. Now, of course, the political motivations that produce the federal constitution are complicated, and there's lots going on, and there are obviously, as Willy and Joey point out in their book, strong sort of political, economic, and egalitarian impulses animating at the time. But there's also this opposition to this radical state constitutions. And there's the devil's deal between the North and the South, and the federal constitution with malapportionment, with the electoral college, with state-based representation, with more minor things that I find deeply egregious, like the presidential veto. Yeah, there are all these structural features of the Constitution that make it really problematic as and limited as a mechanism of sort of creating this new a democratic society. Now, I'll say that all text, I'm an anthropologist. I think we give to text like we give to all social practice meaning, rather than it's somehow just adhering in the document. So I recognize that the federal constitution could be read to mean whatever we want it to mean, that there is no inherent limit. But I also recognize that it has meaning today, and that meaning is hard to change, and that, just as Ash noted, it creates and authorizes certain forms of political economy. So on the one hand, I think it would be foolish for progressives to totally get out of the business of making these kinds of doctrinal constitutional arguments aimed both at courts and at legislatures, because the right is making those arguments and they're doing a terrible job. I think, I'll just speak about the First Amendment. I think the arguments that are made for how we understand the First Amendment, these kinds of formalist, idealist arguments for how we think of free speech are terrible, because they don't match well with the democratic aspirations that are redolent in the history and the present tense conversations about freedom of speech. And so I just think they're shoddy arguments that happen to be extremely successful because of the composition of the courts, but also because of the failure of those on the other side to make very full-throated arguments in response. So definitely part of the strategy, I think, inevitably has to be a short-term strategy of responding to these arguments, making other kinds of constitutional claims that are more sensitive to, I think, a much richer understanding of what it means to possess and to wield rights and what it means to have an imagined democracy. But this is where the ambivalence comes in. But does that mean that, is that the only strategy that progressives should hold? Or does that tie us too much to a document that has deep structural impediments? And so I think the question that we should be thinking about, I mean, that we clearly are thinking about today, is how to wield that ambivalence, how to both make those arguments without being sucked into a constitutional discourse that says, so long as, and I think the incentives of the legal academy make this very attractive, that if you can just make a better argument and you can get a good law review placement and people will read it and maybe a judge will cite it or two, that's the way forward. And maybe that only gets you so far, or maybe that actually gets you nowhere at all. Just maybe it gets you a nice job. And you're right. You're convinced by your own arguments. But I am intrigued by this idea of norm breaking, or rather how we might imagine the Constitution or reimagine the Constitution more aggressively, perhaps, than just thinking about the meaning of the free speech clause. What are the possibilities for thinking about transforming the, what was the phrase, the political economy that the Constitution enables in productive ways? That seems to me to require more than a clause by clause interpretation, but it also seems, and it seems to require a kind of a political mobilization around an idea of the Constitution as a liberating, or as something that could be liberating in this important way. But even then, I'm ambivalent about that, because that's where federal constitution is a deeply problematic document with a deeply problematic history. This is, I guess, why I was curious about the history, the role that history should play in constitutional discourse. And so for progressives to wield this, perhaps it is the only tool, the best tool we have, because it is, we live in a constitutionally fetishistic society where the Constitution has power. But I do think that we should have a lot of ambivalence about it.
Great. Thanks, Genevieve. I take sort of yours and Ash's comments in some sense to be about how maybe we need to think, and we should actually put much more energy on something which lawyers are not in a way trained to do, which is take the Constitution from outside rather than inside. And Dave, one of the things that you've done in some of your work is speak about how sort of thinking about the Constitution from inside actually has involved all kinds of surprising arguments entering the fray, all your sort of anti-modalities work, so on and so forth. And I was wondering if you could just speak a little bit about sort of just the nature of sort of that distinction, right, in some sense.
Okay, thanks, Maeve, and the organizers as well. I'll try to answer that, but can't help but try to pick up on what Ash and Genevieve just laid out and try to build on it a bit. So Genevieve highlighted the ambivalence that pervades this conference. I think I'd like to suggest that that ambivalence reflects the ambiguity of what it would mean to constitutionalize political economy. So even if we could agree on what is this political economy we'd like to see achieved, let's just stipulate that it's Joey and Willy's democracy of opportunity tradition and all of its entailments. I still think it's highly unclear what it actually means to constitutionalize that project. And I think there are very different risk-reward profiles depending on which move we make. And that this might illuminate some of the ambiguity or the ambivalence, rather, of the tension we feel. So let me try to walk that through briefly by way of answering Maev's question. So one space in which I think that we could proceed differently in constitutionalizing political economy is as an interpretive project. So there are kind of lower stakes and higher stakes versions of making a constitutional political economy move when it comes to constitutional interpretation. So I think the lowest stakes version is almost invoking Joey and Willy's democracy of opportunity tradition or some other political economy as a kind of atmospheric. It's not a claim or a set of claims about the truth of the Constitution as a legal matter, but claims about historical or moral frameworks that might bear on constitutional questions or help us understand the stakes of the problem or spark outrage or elicit sympathy. So these kind of indirect atmospheric moves we make around constitutional argument and just throw in the mix the fact that people used to talk vigorously and in a quasi-constitutional key about political economy issues, along with all the other standard tropes in our constitutional discourse. That I see little risk to that, but also not a clear benefit. A more aggressive and a slightly higher stakes move, I think, would be to try to assimilate claims about political economy directly into the standard forms of constitutional argument that are recognized as legitimate today. So we could do originalist jujitsu, as many scholars are doing all around the academy right now, and try to show that actually the original public meaning of this or that provision, properly understood, is more progressive than you thought. The founders had no non-delegation doctrine. They actually thought that the preamble wasn't merely hortatory, but was a source of national government authority. Pick your favorite progressive originalist move. We could try to elevate the strands of doctrine that still have anything progressive left in them, and bring them to the fore. We could do the standard textualist jujitsu move of converting a negative right into a kind of positive right by saying we need to attend to the functional prerequisites of what it would take to realize that right. So in the First Amendment context that came up earlier, there's an old strain of First Amendment thought that says, if you want to speak freely and effectively, well, you need a lot of things. You need a right of education, actually, to be able to make informed and persuasive speech in the public sphere. This was litigated in San Antonio Independent School District versus Rodriguez unsuccessfully, but we could recover those kinds of moves. And then still more ambitiously, and I think higher stakes, than trying to weave progressive political economy themes into the existing modes of constitutional argument, would be to change the modes altogether, create a new grammar of constitutional argument that recognizes claims of political economy in new ways. And I think Joey and Willy's book actually pushes in this direction. That could also take many, many forms. It could involve changing the way we think about structural constitutional arguments, which receive the most attention in the book, to not just be about the relationships across different institutions set up by the Constitution, but also about the structure of society more generally, and access to material resources and opportunities. So we could blow out the structural, modality. We could just allow straight up normative, deep, comprehensive normative arguments to count as constitutional arguments, and argue directly from, social justice or democracy of opportunity, and say that that's a claim about the truth of the Constitution, not just an adjunct to, standard forms of constitutional adjudication. Okay, so this is just to say, there's a broad spectrum of ways in which we could try to influence constitutional interpretation by bringing in political economy, all the way from just changing the scenery to making brand new claims about constitutional meaning. And which way you go depends on the costs and benefits. The costs and benefits will depend on which way you go. Secondly, I'll be briefer here. There's also an institutional question about what would it mean to constitutionalize political economy, not just at the level of interpretation, but also at the level of institutional implementation. Again, I think there are low stakes and high stakes version of this. The low stakes version would be, or various low stakes version would include, let's submit more Brandeis briefs to the court, bringing in more history in the spirit of Joey and Willy's book, so that everyone can understand the broader context. In the floor of Congress, where most of the book's arguments are directed, we could just ask representatives to invoke the Constitution more. When they are trying to pass better healthcare bills or poverty relief bills, we should urge them to say that the Constitution supports or encourages or even requires this when they do so. And just use the C word more often on the floor of Congress. And by the way, I'll just note parenthetically that I did an empirical study with Eric Talley here at the law school and Julian Yarko at Stanford a few years back on how Democrats versus Republicans on the floor of Congress talk about the Constitution. And it is the case that Republicans today invoke the Constitution much, much more than Democrats. And indeed, the only parts of the Constitution that Democrats invoke more than Republicans are the Reconstruction Amendments. But the overall rate is highly disparate. So we could just have more constitutional talk on the floor of Congress. Okay, those I think, again, are unobjectionable, might help at the margins, but are low stakes. bolder versions of institutional implementation of constitutional political economy might include congressional defiance of the Supreme Court when it issues rulings that are counter to Congress's best understanding of constitutional political economy. Or Congress just exploiting whatever discretion is left over from Supreme Court opinions if we're wary of outright defiance. Maybe we can go beyond Congress and think about popular or state defiance of Supreme Court rulings. I think you can't really develop an account of congressionally centered constitutional political economy that doesn't wrestle with how the court's going to respond to unfavorable court rulings, that we're going to feel much more or less ambivalence depending on how aggressive the posture is there. I think I should wind up by just saying on the peril side of any but the lowest stakes versions of these moves, I think there are a standard set of perils that have kind of hovered over the conversation that maybe haven't been named directly. That might be helpful to lay out. One is, I think Genevieve was getting at this, just crowding out other forms of argument and mobilization in a non-constitutional key or other reform strategies, that might better serve progressive ends in the end. I guess that's pretty obvious. Second, though, I'd add is narrowing pathways for compromise and inflaming social conflict. If we constitutionalize more and more issues, there's a tendency to create kind of winner-takes-all dynamics, and would we actually better be able to achieve the outcomes we want if we deconstitutionalize certain issues and talk about them in the realm of ordinary politics? I can give examples of where I think that's worked better when things have not been constitutionalized, but I won't for the sake of time for now. And finally, there are other projects out there that don't share progressive values that would also like to constitutionalize more swaths of our public life. Think about Adrian Vermeule's common good constitutionalism as a leading candidate on offer from the quasi-authoritarian right now. There are, just to say that more and more issues need to be talked about as constitutional, we need to recover the sense that the way we organize ourselves economically has constitutional stakes, doesn't necessarily cut in a progressive direction. There are also traditions of economic libertarianism, not to mention racialized social control in this country, that could be recovered by some that would lead us to a very different place. And I'll end by just noting, I think it's an empirical question. At the end of the day, what's going to lead to a healthier constitutional political economy? Any combination of the matrix of interpretive and institutional moves I just tried to sketch out, or a kind of non-constitutional politics where we just take things out of the constitutional realm when we talk about political economy, or even an anti-constitutional politics, as Sam, I think, has become a leading exponent of, where we work actively against the Constitution and try to change it. It's an empirical question. What's going to lead to better progressive outcomes at the end of the day? And it's a very complicated, contingent empirical question. And that I think goes beyond the tool set of lawyers. We would need to poll the public on what arguments are more persuasive, to name just one thing. But maybe it's helpful just to realize that when we talk about constitutional political economy, changing the modalities of constitutional argument is one thing we might do, but there are actually many levels to that issue that I hope we continue to work through.
Thanks a lot, Dave. I think sort of the
over sort of constitutionalism point is actually in some sense at the heart of the ambivalence, because in a way the backdrop for this event and the book is a sort of is a just concern with capital and with its influence, but historically and globally you may think that over constitutionalism is actually just very close to a kind of state absolutism. And so what you will actually result in is you'll remove the concentration of power from one domain and just take it into another. Sam, you were already invoked, but you've suggested that in some way we should not only de-emphasize the Supreme Court, but also de-emphasize the Constitution in some sense. And I wonder if you could speak a little bit to the tension or the ambivalence or the puzzle about, on the one hand, trying to sort of de-emphasize the Constitution, on the other hand, thinking that maybe we should just need to emphasize the Constitution as being something very different?
Well, thanks, Madhav. I'm not sure how to intervene here because people are giving opening statements while also kind of engaging slightly with Madhav's question, and I really would like to do a little of both myself, but I'll try to be briefer. When I first heard the phrase constitutional political economy and was assured that it was a deep American tradition, I also reflected on the fact that it's also a kind of self-branding exercise and that the phrase really emerged 5 minutes ago. And I'm still trying to kind of reconcile these two facts. And part of the way I've tried to make headway in thinking about the great book that's at least provided the occasion for these conversations is just trying to focus a little bit more on defining the terms, because there's a lot of instability in the way the different parts of the phrase constitutional political economy are being used, and I think it bears on the answer I want to give to Madhav's question. You could, by constitutional, mean political. And if that's what you mean, then there's really no reason not to use the word political, unless you're a constitutional law scholar who wants to assert special ownership about what we should do now. On the other hand, you might mean something different, really important commitments that are functionally entrenched and really important to keep off the agenda of short-term politics. And there might be, more reason for lawyers in general and constitutional lawyers to take up that meaning of constitutionalism. The one I've been polemicizing against is even narrower. It's really the idea of a written document that formally entrenches certain arrangements. And I just don't think Americans should avoid the fact that we have such a thing, and that it's toxic, and that it inhibits any future reforms that we might want to make, including to change our political economy. And if that's the case, then we should focus on that fact at least in some of the time. I suppose I think that there's then a question about what you would do if you had a sufficient political coalition to alter the Constitution, undo some of the constraints it places in this formally entrenched sense on American politics. Now, I should be very honest in saying that I'm not sure looking to the past is going to be helpful in getting to that point. And that's maybe the biggest difference of opinion between myself and the authors of the book. I would say the book is a kind of classic move. It's an invention of tradition, an exercise in finding friends in the past when we don't have enough now. Because it's just a fact that there isn't a progressive political coalition to face the very hard fact that there are these legal constraints that just not enough people yet want to surmount. And I'm very dubious that saying things like we need to reclaim the Constitution will add to that coalition. I'm very dubious that presenting some alternative vision of the United States in terms of the United States Constitution will add anything to the basic task, which is to constitute a political majority, to extricate ourselves from the Constitution in this formally entrenched sense. And I think that a good example of a problem to face frontally is our eternity clause. So as you all know, there are eternity clauses in global constitutions. In 20th century examples, they protect things like human rights. Our Constitution in Article 5 protects the Senate. And if we don't have an answer to what it would take, what we would want to do to circumvent our eternity clause, to lessen the power of the Senate, then we're really dodging a central problem. And no amount of talking about the Constitution or constitutionalism will suffice to provide an answer to what we think is a legitimate, what political acts, what proposals we think are legitimate to circumvent this hardwired toxic feature of our document. And there are other such ones, but that's a flagrant one because it's an unamendable feature. So I think we should focus on these really hard problems, which I think should lead us to think less about scholarship as and really public discussion as an exercise in claiming friends in the past when we don't have them in the present. And then I think we should turn to the second part of Joey and Willy's phrase, which is political economy. Now that phrase, in my understanding, was the original name of the discipline of economics. And it was then revived recently by the left to claim that we needed to displace the economics department with some new form of knowledge. And that is a phrase, not a plan. And I think even phrases like democracy of opportunity don't provide us with any kind of programmatic view of what we would do if we wanted to attract enough friends to challenge the constitutional order and replace it with some different economic vision. I think the truth is that constitutional law professors have little to no authority or knowledge to think about that problem. And I think there should be some honesty about that fact too. So, I guess I'll conclude by saying, I think it'd be really interesting to figure out what kinds of things constitutional lawyers can do. And my own conclusion is that they can mainly provide a kind of negative role of trying to help a political movement when it begins to build even more than in our day, get the Constitution and those who defend it out of the way of whatever a political majority on the left, if and when it comes about, wants to do.
Joey, do you want to defend any of your friends in the past?
Absolutely. This is, first of all, thanks so much to the organizers of this terrific event, especially to Kate and Caitlin and Jessica and to everyone on this panel and the other. I think, and the ones to come, I think there are a few things to say to kind of bring together a few of the lines of critique or just disgruntlement or ambivalence that have already been laid out, setting me up perfectly to discuss the promise of constitutional political economy, and I think more to the point, the perils of the current reticence that progressives have about a constitutional political economy, which are deep perils. So first, I think that, all right. The two ways of thinking that that Ash laid out at the beginning. When you look at the period in which, the period since the Civil War in which there have been the most successful constitutional reforms at the federal level and also state, that's the progressive era, what you start to see is a lot of people who are invoking an urgent need to reform the hardwired structural features of the Constitution, such as the state legislatures electing the Senate. Instead, we got direct election of senators, such as the lack of direct popular ability to get around entrenched corrupt legislatures. In the West, we got all the direct democracy reforms. We got a sort of massive wave of structural constitutional reform, including several Article 5 amendments. And these came from a space of critique of the constitutional order and a set of arguments that we needed to make these reforms to vindicate underlying values that are identifiably part of our constitutional tradition. It was both. It was both at the same time. And I think, while of course the current deep political crisis is not quite the same as the set of overlapping crises of 100 years ago, I think it's a useful reminder to us that successful reform of structural features of the Constitution in the past has not been from a place of sort of pure rejection of the Constitution, but from a place of this kind of combination that in the book we find recurring over and over of critique and revival of underlying, as Willy was suggesting earlier, creedal ideas that we can identify as authentically ours and authentically part of some American past. So, why do we keep seeing that pattern? Well, partly, I think it's because, as Genevieve was saying earlier, we live in a country that, in actual current fact, is deeply ideologically pro-constitutional. And I think this creates a very challenging, heavy lift for Sam's kind of hope of just doing politics in a non-constitutional way. I think we're not, as a country, there, and that's because we have a lot of attachment to some idea of the Constitution. But I think, and this is where I feel like Sam and I and Willy actually come together, the Constitution does not have to mean a legalistic, it's the written document, it's to be interpreted by constitutional law professors, judges, and lawyers only. It hasn't meant that. It hasn't meant that in the past. I appreciated what Chris Desan in the first panel described as the purpose of going back into history as a radically denaturalizing one. That's how I see part of what our book is up to. We're trying to denaturalize the present court-centered constitutional order so that we can think a little bit about what constitutional politics could look like if it institutionally wasn't so focused on what's going on in courts. And I do think that that involves a little bit of decentering ourselves, a little bit of less authority for constitutional law professors. That's where another place where I think Sam is right, that we have through most of American history, we've had a kind of constitutional order where everyone agreed that you fought about it through ordinary politics. And there's a deep irony, I think, in the suggestion that doing that, fighting about the Constitution through politics, crowds out, as Dave was suggesting, potentially crowds out other forms of political argument. Because we only need to look to the current conservative form of constitutional politics to see that it's just the opposite. The constitutional arguments turbocharge the rest of the arguments. We have a kind of fruitful and very sort of productive for the right back and forth between constitutional claims in court and claims out in politics. This is part of what, and I'm sorry that Reva Siegel couldn't be here to make this case. Much of her body of work is about this dynamic, about how we get from and in between political movements for gun rights, anti-abortion movement, and how there's a kind of productive back and forth between what's going on in constitutional politics outside the court and what goes on inside. So the great peril of not doing constitutional politics, or rather the sort of progressive reticence about constitutional politics, and particularly about constitutional political economy, is that you end up with a situation that I thought was exemplified this week by the oral arguments in the student loan cases, where this is a case, a set of challenges that really involve, shall we say, aggressive, creative, conservative interpretations of structural ideas that are nowhere to be found in the text of the Constitution, having to do with the major questions doctrine, and underneath it really the non-delegation doctrine, that are, conservatives would love to be able to say, this is just a sort of legal, doctrinal, dry fight that's not about our vision of political economy. I think commentators, even liberal commentators on these cases, I didn't just listen to the oral argument, I sort of read some of the legal commentary, and you have all of these commentators, even on the left, who are sort of focusing on the legal and doctrinal niceties of these cases. But the justices are not obliging us. The justices are going straight to the constitutional political economy claims. You have at least 3 of the justices in the oral argument, and I'll just say one more thing about these examples to bring it to life a little bit for you, focusing on an imagined example of, well, what about if you had someone who, instead of taking out a student loan, took out a loan to start a lawn care business, and that loan is not being forgiven by the Biden plan being challenged in court, and is that fair? And what this really is a kind of anti-redistributive constitutional political economy vision that you can trace back through. You can see it from the founding, you can see it from many eras of opposition to state debt relief, and this vision is being articulated in pure political economy terms right in front of us by conservatives in court and amplified out in politics. And so there's something very strange about the claim that progressives, when faced with this, should say, oh, but there's such peril in our making arguments about constitutional political economy. But in fact, what I think we need to recognize is that progressive politicians and activists and just Americans have some critiques of what the court is doing. They have some questions about the political economy that's being imposed on us from above by the court. And what they need, I think, is license and authority to say that actually some of these objections that you may have to what the court is doing, you actually can make those claims that the court is wrong about the Constitution, and that actually constitutional values point the opposite way, that we need to have the kind of broad middle class that, from Andrew Jackson to the sort of Reconstruction Republicans imagined that you would build through homesteads and land, or through creating schools, actually having a generation that is burdened by impossible student loan debt is a problem for that kind of constitutional principle that we need a broad middle class if we're going to sustain a republic. So I think what I see as the project of our book is really just giving some material, giving some frameworks and some arguments to people who are already out in the world making these critiques of the current conservative political economy that's being imposed on us by this Supreme Court. But if we maintain a kind of separation and we say keep politics separate from constitutionalism, I think what that does in the present configuration of our political culture is it just cedes all the ground to the court. And it cedes all the ground to a court that is engaged in constitutional political economy already. So this is sort of flipping the frame of the panel. This is the peril of not engaging in the political economy debate that is happening in a very one-sided way today, not just in court, but in the politics that's fueled by what the court does. So I think that's the kind of core intervention that that we're trying to make. And now I'll be quiet so we can have more of this great discussion.
Genevieve, I was wondering if I could bring you in, because in some sense that it ties in with sort of the point that you began with, that there is actually no other way to think about the Constitution.
Actually, I was going to say, I think there was such interesting. It was interesting hearing the last three presentations, because especially Dave starting by laying out all the options, Sam saying, no, we should focus on this one, and then Joey saying, we have no alternative, we have to use these arguments. And it was making me think, so sort of the Pollyanna story of progressive ambivalence about constitutional political economy is to say that it can be very generative, because it can suggest that we should operate on two tracks. We can recognize that this is a mode of argumentation that is pressed upon us or is inevitable, also just, it might be more correct, a particular view, I guess I should specify what I mean, but a particular conception of sort of materiality of constitutional rights and meaning. So that's just one track, but also recognize, because this is what ambivalence leads you here, one hand, the other, right? That there are profound limits to and problems with the sort of structural setup of the federal constitution. And so there should be one set of progressives working within the frame of existing institutions, and another set of progressives who are doing, I think, closer to what Sam wants, which is to pushing against and trying to figure out a politics that can lead to the sort of structural transformation, the easing of these impediments, both large and small, so changing the role of courts, changing the makeup of the Senate. We could go bigger. I mean, there is this question about, like, what are the aims? Do we want to have a society that is organized around states? There are these deep questions about what are we trying to imagine, but at least generating a kind of politics in which that is on the table rather than off the table. That seems great to me. Like, let's do both, right? There are these immediate concerns and problems we have to deal with, and I agree with Joey, you can't entirely see the ground, but on the other hand, that, there are these other things to worry about. That's a happy story. I think that the more negative story is that if we look at history, what we see is that when progressives get success in making these kind of progressive constitutional political economy arguments, they do what you want them to do, which is they, in a full throat, and I think Kagan was trying to do this in those arguments, make arguments push against the conservative or conservative imagination of the Constitution. The worry is that that leads to complacency, that there is a concern that if we imagine the Constitution as not such a terrible thing in our lives, it can be used to good ends, then who needs to really change the deep structures? You just need to have better arguments, and you need to have, like, really good leaders. You need to have FDRs who can mobilize the masses, and maybe you need to intensify the contradictions of the Constitution. I think this is what we saw with the New Deal. You need to amp up the powers of the imperial president, because you hope that the president is going to run roughshod over some of the constraints on his power and achieve progressive ends. But that's not a happy story to me. And so I guess there is this worry about, can progressives operate with two hats? Can ambivalence be used productively to go at two different registers? Or is this, and this is, like, I don't know. I don't know how to think about this. I think this is an empirical or sociological or a theory. I don't know how to answer this question. But is there a danger? I think some of what is motivating ambivalence is an anxiety about the seductiveness of winning in the small scale battles, that's going to undermine the energy for the large scale battles. And I don't know how to think about that.
So in the preceding 40 minutes, conversation shifted from a discussion of what constitutionalism is to a discussion of the comparative statics of constitutional politics. That's not a bad development or a salutary development, but it is a change in the type of discussion we're having. And I think Dave and Sam in particular, Dave set up the sorts of empirical questions one would have to answer. Sam gave a claim about what he thinks the empirics look like, and Joey gave us a counterclaim about what he thinks the empirics look like, the fixed constraints of pro-constitutionalism in American culture. And I think others in the audience have yet a different view of that. For instance, I think of Aziz's work about constitutional reverence and perhaps the need for some constitutional irreverence. Now, those are complicated questions, just like the historical question of whether MLK would have succeeded without Malcolm X being there. And my general impulse towards all of this is to say, this kind of makes me feel like these aren't our questions to answer, really. I'm not a political strategist. I'm a scholar. Like, that's what I do. And I'm interested in asking questions about the nature of legal argument or constitutional history or whatever. And I think as a piece of scholarship, the book is an example of a very interesting reconstruction of a historical period. I believe in the intrinsic value of scholarship, and I look at those arguments, and I think that's wonderful. If we decide to read it in a different genre as a political strategy guide of some sorts, then I'm not saying it is, but one can read a serious piece of scholarship in various different registers. If we decide to read it in that register, then all the questions that Dave, Genevieve, and Sam have raised start to make it very muddled. And so where we are is we find ourselves in the uncertain contingent space of politics. And that is a space in which, frankly, I'm much more content to let the organizers take the risks and the people on the ground take the risks and take my shots in writing editorials. Or like, I don't really write editorials, but many of the people on this panel write great editorials, the best editorials. But you know, it sort of raises a deep sociological and I think introspective question about like, what is the enterprise? And that's fine. I think people can reach different conclusions, but like, I'm simply not equipped to answer the question of what are the fixed constraints of constitutional politics. I call this a long-winded statement of impotence.
Sam, given that you might be sort of, your writings in some sense might be seen as the most political, right, at this moment. I guess I was wondering if you could say something to that, but also with a sort of additional question that I might impose on you in the way in which Genevieve sort of set up the two tracks, right? And one can see the appeal of it. It's like sort of one's Marxist friends buying a lot of private property, but also keep on writing about, you know, how the world needs to not have it. But I
Quite what I meant.
but I suppose that there's one way in which I imagine that if we did make the constitutional arguments and we did win, right, I actually still think that you would probably not be happy, because the way in which I've read your work is not to say that we need to rethink what the constitutional order should be in terms of political economy, but we need to rethink the nature of American constitutionalism in contrast to, say, the UK, for example, where entrenchment has a much more significant role. And it could be that you actually remove entrenchment or have a much weaker form of entrenchment, and you still end up with a highly capitalist order. That might also be a problem, but it won't be this problem.
Yeah, that's helpful, Madhav. I mean, just to you know, in the spirit of narrowing any potential differences, I mean, I'm not for unilateral disarmament. I mean, clearly it's the case that when our main friends, if any, are, you know, in ransacking the past and the right is in charge of the court, there are, you know, regardless of what I say anyway, there are going to be some people who face down the constitutional claims that are, you know, driving the right wing and try to limit the damage. And that's completely, I think, defensible as one form of politics. The question is, do we then take the extra step and say, actually, the Constitution is on our side, not just in this or that case, but in the political vision that it is already in the Constitution as a document or constitutional traditions. That's why I refer to kind of a negative constitutionalism in my first intervention. And what that would involve then is clearing the way for the legislature to act in the name of whatever consensus on the left or right, if it wins, emerges. And I suppose, you know, that I'm also a skeptic of just the move of taking the Constitution away from the courts or pluralizing the actors that can make claims on the Constitution, because if we mean by that the legislature gets to make the law without opposition from the Supreme Court, then what we're really talking about is the Constitution as rationale for statutory work. And if that's what we think that we should aim for, then I think we should say we want a statutory order as the place the law is made. So that's Mada's question, I think. Do we want then, when we have the power to make the statutory order, to entrench any features of it? The other side might win, change the law again. We might get tired of fighting the battles. There might be things we care a lot about. Civil rights, just to take an example, where if we had power briefly over the statutory order or a supermajority to make amendments, if we would stick with our current constitutional order, we would use that power to entrench our utopia. And Mada's right that I think not only are we, years and years away from that, very hypothetical possibility, but it seems like it would be a mistake. We've seen entrenched law serve adverse interests to reform of the country historically, and with very few counterexamples. And so I'm also making, as I think you're pointing out, a principled argument. It's not relevant now, but in a hypothetical situation where there was actually a chance to make policy, progressive policy, with a sufficient majority to do so, a sufficient supermajority to clear the constitutional obstacles, would we want to then go ahead and entrench those policies? And I think that's, again, a question of principle, a question of strategy. It has, I hate the term empirical, because no one has answers to these questions empirically. They're going to be bets informed by history, some sense of, what the risks are of one course rather than another. And I do think, one big risk of the constitutional political economy discourse is that it could distract us from the possibility that once we have cleared away the obstacles that the constitutional order currently imposes, that we could embrace entrenchment as if it would serve us, as if it would save us the trouble of perpetuating our values as long as we want them perpetuated, because that's the only thing that would guarantee that they're institutionalized rather than not.
Can I jump in here on entrenchment? I appreciate what Sam was saying, but I actually think we're thinking about entrenchment somewhat the wrong way. There's one model, which is entrenchment is when you get something into the Constitution, whether the text or otherwise, and then courts enforce it and keep politicians from changing it. And I think part of what Willy and I are doing in our discussion of this in the book is trying to decenter, denaturalize that way of thinking about entrenchment. I mean, the book is really centered on Reconstruction, and the way that the radical Republicans, and indeed the mainstream Reconstruction Republicans, thought about entrenchment was not, we put these words in the Constitution, then the court keeps politicians we disagree with in the future from, undermining them. That was not the plan. The idea was we enact these amendments and make changes to the political and constitutional order of the country in such a way that there will be a durable majority, a multiracial majority for capital R Republican politics. This is why they made a lot of use of the tool of statehood admission, which is the only tool we really have to, without total constitutional revolution, deal with the problem Sam brought up at the start. And so, this is why DC statehood is sort of a hot topic right now. And, that's a tool. The Republicans used it quite effectively. Indeed, after they ceased being the Republicans of the 1860s, they were still admitting states that still today give a durable extra vote to the Republicans. So I guess I see entrenchment as in part a story about the way the Constitution, reshapes politics. And part of what we do when we make constitutional change is think about building the constituencies who will create a durable future politics to protect that change. And I think you see that as well in the New Deal. I mean, the famous example of how Social Security becomes entrenched is not that we create a constitutional right to Social Security that's judicially enforced. It's that we build a program that has a massive political constituency because everybody's paid into Social Security, and so they expect to get it out. And even today's radical Republican Party is sort of falling all over itself to disclaim its own proposals to dismantle Social Security for this exact reason. And so I think it would be a mistake, however, to say, oh, well, that's not constitutional entrenchment. That's, some kind of political entrenchment or something like that. Because it's a constitutional fight to get any of those things in. The constitutional fight to create, Social Security and any of these New Deal programs, for example, in the face of arguments that all of this was unconstitutional, I think is illustrative of that. And so, anyway, this is just sort of some thoughts about entrenchment. But the last thing I'll say, I wanted to go back to a point much earlier of Ash's. I totally agree with Ash that, Willy and I are not political consultants either. We don't know, what will be the right moments to use some of the materials in this book. We did an event in Washington recently and talked actually with a lot of people on the Hill and in advocacy groups in DC who had a variety of takes, but wanted to use this material from the book in different ways. And I think the reason for that is because it creates a license. I guess the last thing I'll say to try to articulate this license point a little better is there's a way for con law professors, to say, well, we're just going to get out of the way and let organizers and people doing politics do politics, and we'll do whatever it is that we then do, I guess, doctrinal law. The problem with that is that it reinforces the separation of the domains, of those two domains. It suggests that there's a big difference between like the large C constitution that you can go in court and litigate and the small C constitution, the sort of set of commitments that we might have out in the polity about either that we do need redistribution or that we need to stop it, or any of the constitutional political economy arguments that all sides make. It makes them very separate. And that separation empowers the kind of current conservative alignment of let's get our way through the courts and tell all of Americans that they don't get to have a say about the issues that are central to our political economy because those are constitutional issues. They're above your pay grade. Defer to the lawyers. So as lawyers, I think one of our key roles is to tell people, no, don't defer to sort of, we don't have some sort of completely separate, special inside knowledge of the real Constitution that is inaccessible to people out in politics. I mean, this is the idea that the Constitution is, not a lawyer's charter. It's central to future politics that's able to challenge the court. You need to not make too sharp a line between the domain of what law professors do and the domain of what organizers do out in politics.
Dave, I wanted to bring you in just before we sort of open it up to questions.
I'll just be brief and say that maybe 2 points. One is I think the lawn care anecdote is it's unclear what to take away from that. So some of the conservative justices basically say at the oral argument, is this fair that the lawn care business owner doesn't get the debt relief that the student does, graduate does. I'm not sure that's a claim about constitutional political economy at all, not just because it's nothing is, the word constitutional isn't invoked, it's a statutory case, but I think that's probably more naturally understood as a presentist claim about not the law, but about fairness. You know, Justice Alito is saying, I'm not sure this plan looks fair to me. And the counter to that, I don't think is necessarily, but you should know there's a long constitutional tradition of debt relief, including to those with higher educational attainment, you know, in this country. And the democracy of opportunity tradition fully supports this. Let me find some history for you, some friends from history, so much as no, let me tell you why it's fair today, you know. And so if there's a failure there to meet what the right is doing, I'm not sure it's a failure of constitutional imagination so much as a failure to make a winning claim from justice, fairness, and politics, you know, today, or you know, to the court. Okay, that's just a little point. But then I guess I'll just say I think the key submission that Joey's made here, looking forward, is this notion that constitutionalizing political economy, whatever exactly that means, could help turbocharge, to use your term, progressive politics in the way that something like originalism or comparable projects on the right did for anti-progressive politics in recent memory. And as everyone has said, that's a complex question of political sociology about whether that turbocharging could happen. I'll just note there is, and maybe empiricism can't give us an answer, but there is a body of work that I think suggests a cautionary answer. I'm thinking of Jamal Green, for example, on the faculty here, who's analyzed the political sociology of originalism and what allowed it to play that turbocharging role, and lays out a story of basically it was particularly simple and tractable for a public audience. It tapped into founder fetishism and other themes that were already prominent on the right. And perhaps most importantly, for a political program that mainly wants government to be shrunk and courts to stop government from doing things, rather than articulate an affirmative vision of things government needs to do, it may just be more useful to put things in a constitutional key because there are more obvious textual and doctrinal tools to block government action than to force government action in our constitutional tradition. So, you know, they're hard questions, but I don't, and also, again, everything depends on what you mean by constitutional political economy. If all we mean is to convince people that a new wealth tax, you know, is constitutionally permissible, or that there's some moments in our constitutional history that suggest it would be advisable, is very different from saying it's constitutionally obligatory that we have a wealth tax, and should the court try to stop that, the court is acting unconstitutionally in whatever institutional rebukes could follow. So, so the question depends on how we specify what we're up to. But I guess I just want to say, case not proven that this turbocharging could happen yet. Case not even made, because we really need to specify what we mean by constitutionalizing political economy and what these positive feedback effects would even look like before we might want to invest big resources in going in that direction.
Great, thanks, Dave. I'll just say one thing, Joey, in response to sort of the turbocharging point. It's kind of what Dave said, which is that, but in a different way, that one could sort of read the turbocharging and think, oh, I certainly don't want to go down the constitutional register, because that means that, and again, this could again then be turbocharged by the other side. And it, like, it's not clear whether the problem is then with the topic or with the register, right? But I'm just going to open it up for questions because we have about 10-12 minutes left.
I think this question is directed mostly toward Professor Moyne, but anybody on the panel is, of course, welcome to answer. I'm very interested in this idea of shifting our focus away from the federal constitution, but I'm hoping you can comment maybe on sort of a vertical perspective. You know, we may be at a crest of federal penetration, but is it possible for state constitutions, which tend to be much more living, literally closer to the people, much more easily amended, to sort of fill the political economy role? And well, I'm just curious about your comments on that, and maybe if there's some history there that you want to comment on too. Thank you.
No, I mean, others in this room are better situated to talk about federalism and progressive federalism and so forth. I mean, you're asking like a predictive question. I mean, it could be that with the kind of constitution we have at the federal level, it's more, you know, there are more propitious, you know, agendas down below to seek whatever you want to seek. But then there's this, you know, question of principle. And I think I've, you know, kind of declared that it's, you know, we might not want to go in the direction of constitutionalism at any level, but for short-term gain, you know, I can't imagine that if you had opportunities down in the States to exploit, that you wouldn't want to do so. The question is, do you want to gin up a kind of progressive federalist perspective that celebrates state constitutionalism, for example, because economic and social rights are there? And I think that's a very different question. And on principle, I'm going to suggest that we not do so.
Yeah.
I also have a question on this topic, and it's the apparent lightning rod, so sorry to focus overly on it, but I'm curious whether on the question of sort of abandoning entrenchment, events in Israel give you pause, and what exactly is to be learned from the possibility of the tyranny of a majority sort of surpassing any protections that are afforded in entrenchment?
It's a great question. So, I mean, obviously, it's a very different scenario, and there are a lot of different proposals on the table. But if we just focus on legislative override, you know, I think that's something that Americans should consider. And it's one of the, you know, tools progressives could imagine introducing to circumvent constitutional limitations. And if the fear is that the right has used it in Israel or elsewhere, we always come back to, you know, the basic fact that if you want a liberal American nationalism or a liberal Zionism, you have to build it through assembling an adequate coalition to sustain it. And you can't have jurists, for example, Ahahon Barak, in the case of that country, kind of do it for you or provide a quick fix or shortcut. Actually, if you try, you might produce backlash. And actually, we can argue that we're living through something similar in this country, having tried as progressives, liberal Cold War progressives, to do our work through judicial supremacy. And I think obviously there are risks to disentrenching really sacred norms, but if you begin with the premise that, you know, Learned Hand famously, you know, spoke about, that judges are not going to save you. If fascism comes, it's not like the Constitution or judges interpreting it will stop it. And so the question is really about, given the opportunities you might open up through a disentrenching politics, whether it's the right course for the left, in spite of, you know, the fact that the left loses. You know, loss is a real possibility. No one can save us from loss permanently.
Does anybody else want to just come in?
Well, actually, Sam, I wanted to ask you about this notion that the sort of response to these anxieties is by politics, by assembling majorities or powerful social movements that can advance aims, and by changing hearts and minds. And I mean, in generally I agree with you. But on the other hand, the Constitution creates the conditions under which we do politics and we assemble majorities. None of this politics is not outside of the constitutional structure. The constitutional structure, I mean, we can think about it in lots of different ways. It's enshrining these rights that we care about. But the sort of core, I think, the sort of the simplest notion of what the Constitution does is it's a coordinated device that creates the conditions under which politics occur. And so I guess I find it just, I get my head hurts a little bit trying to think about what it means to deconstitutionalize politics when the Constitution is the precondition for politics to occur. And I think one of the reasons why progressives maybe turn to the Constitution is this, I think, quite pervasive feeling that there is a much more energy out there for progressive ideas and values than is captured in the existing political framework because of the impediments that the Constitution imposes on the ability to do what you want us to do, which is assemble popular majorities or assemble politics. And I feel this myself. And so to me, in that way, it seems like impossible to root around the Constitution. The Constitution is the device for creating the conditions of politics. And I'm just curious what you think.
Just really briefly, because I don't want to, hog. I mean, it is right now, but there's no reason that for the set of rules that constitutes politics to be entrenched. Obviously, most election law is not entrenched, and we might like it if there were more entrenched election constraints, like a federal right to vote. But we could take the opposite view, that it would be best, all things considered, to have the rules that constitute politics just be statutes, and we'd still have a constituted politics. Indeed, the statutes that that we consider really important might be functionally hard to change, just like the Social Security Act. But there's no need to have a constitution, a formally entrenched one, to constitute politics. So, that fact about America now is not really dispositive about, what we should want to get in the long run, clearly.
Hi, I think my question is related because it's about the potential distinction that's come out in sort of both panels about between sort of hardwired institutional arrangements and open-ended text or values. And so I take as part of the project, Professor Fishkin, to sort of locate this sort of affirmative duties for Congress or other political actors to create a sort of political economy. And I'm want to go down a level and look at the states where you have, for example, positive rights to adequate education. But you also have, in most state constitutions, but you also have in 17 state constitutions, like supermajority requirements for tax increases, and in almost all state constitutions, local responsibility for providing public education. And so those two seem to be in tension. And my question for you is whether, one, how do you reflect, could you reflect on the potential tension that also, of course, appears at the federal level between constitutional values and constitutional structure, and sort of how do you navigate that? Thank you.
Sure. Yeah, look, I do think it recurs both at federal and state levels. And I think you see, one of the nice things about state constitutional politics, I've now moved to California, a state that has a robust, problematic, but occasionally hopeful tradition of direct popular constitutional amendment. And so you have a lot of constitutional politics in politics. There's a role for using arguments about constitutional values to critique and change constitutional structures. There's not a kind of perfect line or a clear line, I think, to be drawn between those two. I think there's a way that at the federal level and at the states, you can do this thing of arguing that the Constitution should change, and maybe it's just because Americans have a certain conservatism about how we argue, or you try to find the argument that will persuade the median person or something. So often those arguments are framed in a kind of, things have gone off the rails, this will promote some sort of continuity, even when you're arguing for pretty radical change. So I think there's always, almost always, a kind of mix of both of those things. But a big part of what we hope to do in the part of the book that argues that Americans have, for most of our history, thought that the Constitution imposed duties and not just constraints on legislation, is to try to give legislators, state and federal, more of a sense that they have a license to be constitutional interpreters too. It's really about unsettling a kind of judicial supremacy that lets, because I think this was one of Dave's earlier points. If what you're trying to do with the Constitution is basically destroy lots of parts of government and disable the creation of new forms of egalitarian redistribution, if that's your project, then courts really are all you need. Courts that can say no really are all you need. But if what you're trying to do is build a society that is consistent with not being an oligarchy, but being a broad democracy, then you're going to need to have legislative actions at the center. And therefore, I think it's important to conceive of our current constitutionalism at state and federal level in a way that includes this idea of constitutional duties that has usually been there, but lately has gotten pretty quiet.
Yeah, Dave, do you want to comment? Just
maybe I'll say briefly that I think the question brings out a distinction that might be useful, which is what constitutionally is most hindering the realization of a progressive political economy. So if it's the way in which the various open-ended provisions of the Constitution, particularly the rights guarantees, are being interpreted and applied by courts, then you can imagine how better arguments about what those phrases really mean or what they mean in their entirety, or better, a more usable past could be helpful and lead to new interpretations that would lead to better politics. But if in fact the biggest constitutional barrier to realizing a progressive political economy are the structural features that the federal constitution lack of positive rights, or maybe more pertinently the structure of the Senate, the Electoral College, the fact that we have more veto gates in our lawmaking process than any other advanced democracy in the world, the presidential veto is one of them, then it's hard to see how a new program of making constitutional political economy arguments would get us far, because I don't think there is any tradition of saying that the Senate actually shouldn't be malapportioned in the way it is. Those are relatively textually determinate provisions that you can't interpret your way around so easily. If really those are the constitutional problem is the structural constitution, then I think we need to be talking, as we have in some recent conversations with some people in this room, about formal constitutional change or workarounds to the Electoral College or DC statehood. It's a very different conversation, and one on which I think constitutional history has less to afford.
Willy, you had your hand up, so I'll let you have the last thought for lunch.
I'll be very quick again. Just two observations about, in a certain way, the inescapability of some project in the key of constitutional economy. One goes, everything Sam said about, in response to the urgent question of what about Israel? What about us? I agree with that. Courts can't save us without building up durable majority. Where Sam took it was legislative override, which is one of the several reforms of the Israeli rights going forward. In order to imagine, and I agree with Sam that it would be a good move in these United States, whatever it will do in Israel. But if you imagine it in operation, what is it going to look like? It's going to look like a court still in place, sadly, perhaps, making constitutional arguments to strike down, and a political branch making counter to re-up what the court has struck down. So that at least in that space of structural change, one doesn't necessarily elude constitutional claims. At some point, at least engaging with it in a way that Joey and I think is constitutional political economy. When you're making claims and counterclaims, even if your counterclaims are resolutely in a different key, you're still engaging with the constitutional politics of your foe in some fashion. By the same token, I think it is, part of Dave's recent work on any modalities to say, no, it's not that. It's amendment. Forgive me. It's one of the perils of being like Dave, I love it so much. But Dave has put forward the proposition that the eternal clause in the U.S. Constitution is not so eternal. Dave has put forward the proposition that we can drill down and make good arguments to blow up the Senate and drop the Constitution. Joey and I are saying you may want to think about making some constitutional arguments when you set about blowing up the Senate in the way that Dave suggests. That we shouldn't at least, ex ante exclude the possibility that it will be handy to say there are elements in the rights and values section that help, undermine and remake the structure section. So again, not so easy to.
Great. Thank you all so much. It is easy to escape for lunch. So this is which is now served. And thank you all.